So I know Rainier is here. I had a drink with him last night, and he was always like, so after that, this is kind of a joke. He was like, I'm always on the end. So Barney moved because Barney was with us. And he was like, because you're always late. Right here. Yeah, Barney moved himself, so. Just about 8:30. Yeah. Yeah, I've never been a jewelry guy. The only thing I wear is a watch. I got the Apple Watch, and I gotta say, I was like, I don't know that I'll ever use it. I use it all the time. There's Latasha.
Yeah, I saw her last night.
She texted me asking where we were at.
I
Hey, how are
Thank
you?
you.
You're welcome.
A little bit of amazed, but I made it.
told you it was an email from Sheila, but it was an email from him that actually told us what.
Okay, because I was trying to go back through them and I couldn't find it, so I just texted him this morning.
That's what I did. I went back through looking for it. And I said, well, here's the one from Sheila. Let me check it out. And it's the one that had the ocean spring. Yeah, I saw that.
All right, so you can follow up. So here's the deal. He's a No, I think that's actually. Yeah, okay. Good morning, Ron. Yes, I know. Good morning. Hey, Marion, how are you? Good to see you. Thanks for coming. This is our chairman, Ray Dubuque.
Nice to meet you.
Please tell the senator we said hello. Glad you're here. Thank you.
Yeah, how about you? Yeah?
Right outside the room. Yeah, this is where everything is.
Can't tell, so you did quite a good job.
He's from.
Yeah,
he's
well, I
from
mean, the
Hong Kong.
view, who can beat it? That's nice. I've never been here.
You like your hair?
You have a good trip. You didn't have too far to come. Little is
I said it's still
We do that. We do that though.
too bad.
Obviously, you live here.
Oh, yeah.
It'll be a
Yeah,
sight.
I live way too far from you.
My flight was scheduled to leave at 7, left at 8:30. And I made my connection because I always give you 2 hours in bed in Atlanta. And scheduled about 1 o'clock. So it was nonstop. I ran from the T-Con course to the A-Con course in Atlanta. But it's too far to drive. I'll drive almost everywhere else, but here in Miami, it's just too far.
How are you?
Hey, Ron.
Barney.
Ready for this exciting meeting? Yes, he's here. Certainly excited.
You didn't expect him to change his way.
It was a running joke last night. He was like, I'm always at the end. So Barney like moved him, and
So did he?
Barney said like it's because you're always late.
Quarterback.
He's here. Yeah, he's here. He's just not here.
Okay, thank you. Thank you for taking your seats. We're going to call the meeting to order of the Florida Housing Finance Corporation. Before we get started into the actual agenda items, I would like to introduce former Senator and current Broward County Commissioner Nan Rich, and she would like to say a few words to the group. So, Commissioner or Senator? Got either one. Thank you for being here, first of all.
You can have a seat there or at the standing mic.
Either one.
way.
Morning, everybody.
Morning.
Wow, what a wonderful turnout from all over the state. Thank you for coming. Okay. Thank you for coming to beautiful Broward County. All I could think of, unfortunately, as I walked out and saw that was what's going on in North Carolina and South Carolina. So I'm sure that everybody's thinking and praying for them. I'm really pleased to be here today. I want to thank you so much, Trey and Nancy, for giving me the opportunity to share with you some important statistics about our county, as well as some thoughts regarding a topic about which we are all passionate, affordable housing, or we wouldn't be here. Broward is home to 1.9 million people, which makes us the second largest county in the state and the 17th largest in the nation. We have wonderful beaches, as you can see, 31 unique and special cities, and the busiest cruise port in the nation, all supported by a great international airport. What we do not have is affordable land and enough affordable housing for all the people that work in all of these venues. We have the sad distinction of leading the nation in several affordable housing indicators. South Florida is the most cost-burdened metropolitan region in the nation. 58% of Broward's residents spend more than 30% of their monthly income on housing expenses. We also have the most severely cost-burdened families in the nation. We have the highest housing plus transportation costs for moderate and below families in the nation. These families spend 72% of their incomes on housing plus transportation. The median home price in Broward County is $355,000. As a result, only 20% of families in Broward can afford to purchase a home. The average rent in Broward County is over $1,800 per month. Finally, Broward has a need for over 100,000 affordable housing units. 60% of this need are low-income families. Obviously, there is a housing crisis in Broward, and I know that many of you share it in your counties as well. Affordable housing is the #1 priority for the Broward County Commission, our business community, and our education, health, and nonprofit communities. I bring this to your attention for 2 reasons. First, Florida Housing Finance Corporation is the affordable housing representative for all of us across the state, and we need your help and support. Secondly, I know we all support full funding for the Sadowski Act trust funds. However, Even once that occurs, Broward needs its fair share return on what we pay into the trust fund. In the past 10 years, Broward County has paid over $100 million into the trust funds that has not been returned to this county. Funding for the statewide multifamily programs administered by Florida Housing Finance Corporation has delivered 13,000 units to Broward, while delivering 25,000 to Orange County and 34,000 to Miami-Dade County during the same period. Clearly, inequities exist in the program, especially given the critical need of our area in contrast to the amount we contribute to the trust funds. A fair share of funding distribution has not occurred to date. For fiscal year 2018, Broward County will pay $35 million into the Sadowski Affordable Housing Trust Fund. Only $2.8 million have been allocated to the total Broward County SHIP program. I appreciate the commitment of time and energy that all of you dedicate to housing in our state. And I hope these remarks have just given you a little better understanding of our challenge here in Broward County. I served on the statewide affordable housing work group last year. Several of the members are here today. And I was proud of the recommendations that we developed to address the state's affordable housing needs. The first of which was for the legislature to appropriate all Sadowski funds in the state and local government trust funds solely for Florida's affordable housing programs, the purpose for which the trust fund was intended. Unfortunately, that and other recommendations were not passed by the legislature last year. We in Broward look forward to working with all of you and advocates across the state during the 2018-19 legislative session to ensure that these important recommendations passed last year can begin, and that we can aggressively tackle and solve the foundational problem of affordable housing all across the state of Florida. Thank you.
Thank you. Okay, again, thank you for coming. Okay. We'll now start into the agenda. First of all, before we get to the minutes, are there any consent agenda items that anyone would like pulled?
Mr. Chairman,
Yes.
I don't want to pull anything, but I did want to discuss one item within the consent.
Then we probably need
That's
to pull it. Yeah.
No, it's not a particular, there's actually a number of waivers of the Form 8821. And I was told that maybe a rule change was coming on that, so I just wanted to get more detail with regard to.
Okay, why don't we go ahead and then right before the consent agenda, then we can just
Okay.
have a general discussion about that particular item. So that's great, thank you.
Yep.
Okay, anything else? All right, seeing none, we'll move on to the approval of the minutes.
So moved.
Second.
I have a motion and a second. All in favor?
Aye.
Any opposed? Okay, great. Show is passed. Public comment. Again, these are for items that will be coming up on the action item agenda. Anyone in the public like to make comments on the action items? If you will, please state your name and your organization for the record. And you just flip that back around.
Good morning, everybody. Sandra Vesey-Einhorn, Executive Director of the Coordinating Council of Broward. Wanted to welcome you all to Broward County. Certainly wanted to thank our board chair, Senator Nanrich, for her comments, and just wanted to briefly update you all on the work that the Coordinating Council does here in Broward as it relates to affordable housing. The Coordinating Council of Broward is made up of senior executives that represent government, nonprofit, and the business community that collectively are Broward's largest health and human service stakeholders that recognize that affordable housing was the #1 issue that affected Broward County families. To that note, over the last 2 years, we have worked to build consensus around the issue of affordable housing in Broward County. Earlier this year, we published Broward's first strategic plan for housing entitled Housing Broward, an Inclusive Plan, coupled with the Broward County Commission's very first earmark for affordable housing, a commitment to put money into housing at $5 million per year for a period of 3 years. We then leveraged that commitment and that plan to work with this year's Charter Review Commission through the county. On our November ballot will be the creation of a Broward County Affordable Housing Trust Fund, which the Coordinating Council is leading and advocating for. We are also working towards steps in implementing many of the strategies that came out of Housing Broward, an inclusive plan, including the creation of a public-private housing intermediary, a comprehensive marketing and PR plan that, again, we will launch in conjunction with the ballot initiative. And I invite all of the board members from the Florida Housing Finance Corporation to take a look at browardhousingtrust.com and also to look at our website, ccbroward.org, download our plan, and see how we have strategies for the business community, for municipalities, and of course for developers to all come to the table in a collaborative manner, building consensus around the desperate need for affordable housing units in Broward County to move the needle. We have also created relationships with our partners to the north and to the south in Palm Beach and Miami, and are looking at some regional options to really create some regionalism. As again, you heard from Senator Rich's remarks that South Florida is the most cost-burdened region. We find there to be a tremendous opportunity for us to create some regionalism around that awareness and advocacy, and hopefully be able to have a better voice up in Tallahassee this year for Sadowski advocacy as well. I thank all of you today, and please enjoy Broward County.
Well, thank you. And it's browardhousingtrust.com? Yes. Is that correct? Okay. Very good. Thank you. Okay, anyone else? Seeing none, let's go ahead and move into the first item, legal. Hugh?
Good morning, ladies and gentlemen, members of the board.
Good morning.
The first item before you today is the matter of HTG Village View versus Florida Housing and Marquee Partners. Florida Housing case number 2018-017 BP. This case arises from RFA 2017-113, that is housing credit financing for the counties of Broward, Duval, Hillsborough, Orange, Palm Beach, and Pinellas. Both HTG Village and Marquee were initially deemed eligible for funding. Sailboat Bend, another development, and an intervener was selected for preliminary funding as the first Broward County proposed development, and Marquee was selected preliminarily as the second Broward County proposed development. All these parties filed timely notices of protest. The issues in the case were that HTG Village contested the eligibility of Marquee, alleging fatal errors within Marquee's principal disclosure form. In short, the omission of principle that they felt should be required. Based on the information discovered during litigation, Florida Housing took the position that the uncontested errors within Marquee's principal disclosure form were material deviations, and that Marquee should be ineligible as well as lose the 5 points for that item. This was a change from our preliminary scoring, to make that clear, based on information we got during litigation. At the end of July, a hearing was held at the Division of Administrative Hearings, wherein the judge concluded that the evidence demonstrated that the omission error within Marquee's principal disclosure form did render it ineligible for funding and ineligible for the 5 scoring points. Hello, sir. Okay. The ALJ further concluded that Florida Housing initial scoring finding Marquee eligible was erroneous and inconsistent with the requirements of the RFA. It also recommended that you enter a final order finding that Marquee was ineligible for funding and not eligible for the 5 points, and awarding the funding to HTG Village. Florida Housing and HTG Village filed a joint exception to one paragraph of the recommended order that you have before you. In its exception, we do not, or Florida Housing and HTG Village do not seek to overturn or disturb the ultimate conclusions and eligibility decision by the ALJ. Rather, we're just trying to remove a finding of fact that was inconsistent on its face once we got that after the trial. Marquee, of course, also filed exceptions and plans to present those to you today and argue that HTG Village did not have standing to participate in the hearing, and that Marquis was eligible for funding. The staff recommendation for this item is that you grant the single exception filed by Florida Housing and HTG Village and enter a final order excluding the finding of fact in paragraph 48, and otherwise adopt the remaining findings of fact, conclusions of law, and a recommendation of the order as your final order.
Okay, thank you. All right, do I have a motion?
So moved.
Second. Second, okay. Now I understand Marquis has a representative to discuss. If you will, please state your name and your company.
Good morning, members of the board. Can you all hear me? My name is Michael Glazer. I'm with the law firm of Osley McMullen in Tallahassee, and it's my pleasure this morning to be here on behalf of Marquis Partners, which is part of Cornerstone Group, as well as their partner in this project, the Pompano Christian Clergy Council. The easy thing to do in all of these cases is for you just to agree with the administrative law judge and adopt the recommended order. We're going to urge you this morning to disagree with her conclusions and find that Marquis is in fact eligible in this case. And I'm going to give you two reasons this morning that we're going to ask you to do so. Reason number one, there's a requirement in the RFA to disclose the principles of the applicant. The reason for that requirement is so that Florida Housing knows who it's doing business with. What I've done is I know it's a little hard to see, but this is a blow-up of the actual form that's used in the application. Oops. Okay. This is the actual form that's in the application. It is undisputed in this case that all of the necessary entities and people are on this form. I've highlighted a couple of line items for you. At the bottom, next to a company called M3 Acquisitions, listed as a member and a manager is Leon Wolf. Mr. Wolf was listed twice on this form. The mistake, the error on this form, is up in the middle where there's a company called Cornerstone. M3 is listed as a manager, and instead that should have been Mr. Wolf as well. So what happened is Mr. Wolf was listed twice, but not 3 times on this form. That was deemed to be fatal to the entire application. It wasn't a question of whether Mr. Wolf had been disclosed. He was disclosed twice. And what I'm asking you to do this morning is to determine that this was in fact a minor irregularity. A minor irregularity is defined as one that does not give an advantage to any applicant over another. There is no way to conclude that Cornerstone, that Marquis was given any competitive advantage over anybody else because Mr. Wolf was listed 2 times and not 3 times. And here's the additional point. If you conclude that this was fatal to this application, what you're saying to the development community is to continue to nitpick at these applications, and you're going to have more and more and more litigation as a result of it. Instead, if you say this is a minor irregularity, this is not the kind of thing that's going to be fatal, then what you're saying is we're going to try and disincentivize people from bringing these cases so that you're not spending your time doing this meeting in and meeting out. Reason number 2. HTG Village View was the challenger in this case. HTG is part of Housing Trust Group. Let me give you a timeline. Again, HTG signed its land contract on December 12, 2017. On December 28th, the application was filed. Less than 3 weeks later, on January 16th, HTG gave up their site. They did not extend their contract, and they lost their site control. On March 16th, some 2 months later, the decisions came out. HTG still didn't have its site. But what's really important for this case is that on April 12, 2018, petitions were filed in this case. That is a signed representation by the challenger that they are significantly and adversely affected by a decision of Florida Housing Finance Corporation. And they represented to you that they were adversely affected. And yet, on April 12th, when they filed that, they did not have a site. They did not have legal standing to bring this case when they filed it. And in the course of the litigation around May 3rd, we discovered that. We sent them to some discovery. They realized that we knew about it. They went out, scrambled around, got their site back on May 8th. But on the pertinent date, April the 12th, they had no site. Undisputed facts in this case. And again, if you believe that conduct is inappropriate, then you can determine and disagree with the conclusion, not the facts in this case, but the conclusion that HTG had standing to bring this case. If you adopt this recommended order, you are saying to the housing community, we're going to make it easier, not harder, to bring these cases. And I suggest to you that's not what you're trying to do. So in quick summary, the failure to list Mr. Wolf 3 times instead of 2 times should not impose a death penalty on this project. HTG should not be found to have legal standing. You should not approve of this kind of conduct where they represent to you that they're affected when they're actually not. And what I would ask you to do this morning are 2 simple things. Make a motion to accept and adopt the exceptions filed by Marquis Partners, and after you pass that motion, make a second motion to enter a final order awarding housing tax credits to Marquis Partners. I appreciate your time, Mr. Chair. That's all I have unless there are any questions.
Thank you, sir. I didn't tell you, but we are limiting to 5 minutes, and I started the timer. So
how did I do?
But you did. You've got 26 seconds left, so I'm sure there'll be some more discussions.
I had time.
For those of you that are going to come up in the future, just know I'm going to have a timer running on the 5 minutes. You may want to sit there. There may be some questions from the board. Hugh, would you like to respond to any of that?
No.
No? Okay.
Florida Housing has an attorney here to respond.
Okay.
Besides me, I mean.
Besides you? Would you like to?
Mr. Chair, Maureen Dalton,
Time's up.
Yeah. The mic, please, and again, your name again and the organization.
Good morning. Can you hear me?
Please pull the microphone closer.
Yeah, it's got to be really close.
Thank you. Good morning. My name is Maureen Dalton. I represent HTG Village View in this matter. It's a pleasure to be in front of you this morning. Let me talk to you just a little bit about the first requirement and the first thing that Mr. Glazer talked about. It's a little more important than just not disclosing Mr. Wolf 3 times. What is in the RFA is a requirement that you fulfill the principal disclosure form. The way that that is addressed in the RFA, it leads the applicant directly to the rule, which is 6748.002, paren 93, paren 2, paren B. And what that does is it basically defines the word principal. As Ms. Button has testified throughout the course of this case, when the word principal appears in the RFA with a capital P, the applicant has to go directly to that definition to understand exactly what that means. Within your definition section, it is very clear that depending on the type of entity your application is, you have to disclose different things. What is required if you have an applicant that is a limited partner, as is the case here, you have to disclose your general partner. The general partner here is Cornerstone, excuse me. The general partner here is Cornerstone Marquis LLC is the general partner. The rule further requires that after that entity is disclosed, you must disclose the member and managers of that entity. Mr. Wolf was one of the managers of that entity, and he was not disclosed. And so it's not just a matter of he's disclosed somewhere else, so therefore it's a minor irregularity. Marissa Button testified through the course of the hearing. It is critical that we understand who's in the deal. It is also critically important that we understand exactly who are the players for each particular entity. So it is a little more than they were disclosed twice, should have been disclosed 3 times. On the other issue, because I don't want to run out of time on the standing issue, I believe Mr. McGuire is going to tell you that for standing. And I think it's important that you know that this issue was briefed by both parties, was filed a motion to dismiss, that Judge Green heard all the testimony and all the argument, and basically she determined that HTG had standing when it was required, which is when on the application deadline, We had site control as of the application deadline. The other time that you need to establish site control is at credit underwriting, and that's what she determined. So she looked at all the case law that Mr. Glazer has cited within his brief and determined that, in fact, we had standing. And the other thing that I would point out is that it's a conclusion of law, which this board does not have substantive jurisdiction to modify or reject. And that would be our conclusion.
Okay. Thank you.
Thank you.
Is there anyone else? All right. Should I set the 5 minutes on you too? It's only fair, right? See?
Yes. Good morning. My name is Chris McGuire. I'm one of the attorneys at Florida Housing. Let me address the standing issue first, because that's the simple one to me. Standing is an evidentiary decision that the administrative law judge makes, and we don't have any authority to overturn that, even if we wanted to. I also don't think we want to, because the result of that would be that if we're trying to determine whether at the time a petition is filed and every applicant is still eligible for funding, we would have to go every time a petition is filed and re-review every application that came in and go through every bit of it to make sure that they still met all the requirements of it that they did on the application deadline. And that's just something that we have never done and hopefully will never have to do. On the disclosure of the principles, there are a number of reasons why we require principles to be disclosed. And we have very consistently taken the position that if you don't disclose your principles properly, your application is going to be found ineligible. We've done that many times. In this particular case, Mr. Wolf was disclosed as a person on the form somewhere, but he was not disclosed as a manager of Cornerstone Marquis LLC. And the reason that matters is because after, assuming someone is selected for funding, there are restrictions on how they can change their corporate structure afterwards. And if we don't know who the principals of each of the entities are at the time that they're funded, we'll never have any idea if they're changing principles and moving people around and shuffling things around. We just won't know. And that's why we think it's really important that they disclose not just the names of the people, but the names of the people and the positions in each of the entities that they're representing. And I think that's about all I have to say.
Okay. Thank you. Anyone else? No other attorneys in here want to talk about this one? Okay. If not, board, do you have any questions? There is a motion and a second on the floor, so we're still in discussion. But is there any?
I have some questions.
All right, Mario.
So you stated that M3 was listed on the application?
Yeah. Get real close to the mic.
Oh, this one?
Okay.
Is this not on?
The actual, I'm sorry.
Oh, it's on? Hello? Yeah. Okay.
The actual principles are at the top. Cornerstone Marquis is listed. Cornerstone Marquis is then discussed in the middle, and then M3 Acquisitions, because it had an interest in some of these in these other entities, was disclosed at the bottom. So, again, it's undisputed that everybody and every entity that needs to be on this form is in fact on this form. So, if the ultimate purpose is to know who you're doing business with, it's all right here.
And how did was an org chart submitted with the application? I'm not.
I don't believe so, because this is what's required.
Okay.
And by the way, this form wasn't perfect. There was another mistake on it that Florida Housing said was okay. They waived that as a minor irregularity, but this one they deemed to be fatal.
Okay, thank you.
Thank you.
And then with regard to the site, it was the same site or a different site?
No, it was the same site.
Okay, thank you.
Okay, any other board questions? Okay, seeing none, and we have a motion and recommendation to adopt staff's recommendation, we're going to take the vote. All in favor?
Aye.
Aye. Aye.
Any opposed? Thank you for your time and work on this. All right. Item B.
Item B. Thank you, Mr. Chair. Item B is not litigation. We have before you resolution, or rather draft resolution 2018-036, the delegation of temporary authority to designated staff to consider, grant, or deny requests for waiver or variance of Rule 6748.023(2) Florida Administrative Code. The background on this, in March of this year, H.R. 1625 was signed into law by the President, creating a new subsection in Section 42 of the Internal Revenue Code. This provision permits developers of tax credit developments to average the imputed income limitations of tenants in 10% increments for purposes of compliance with the Internal Revenue Code. The way our current rule is written, it does not currently permit income averaging to impute income for tax credit purposes, and rather the rule requires developers to essentially stick with the information they gave us in the application in the RFA. A waiver of this rule would permit us to let them change that if they needed to include income averaging in their calculation. But as it stands now, interested parties who have recently gone through our system will be unable to take advantage of this new addition to the Internal Revenue Code without a waiver or variance of this rule until such time as the RFAs or the rules amended. We estimate that there are 230 developments in the pipeline right now that could be affected by this change. We have 9 that are actually waiting for this resolution to pass before they get their 8609s. It is likely that most, if not all, of these requests would receive a positive staff recommendation, but it would also require, without this resolution, for each individual case to be brought before the board, potentially delaying the progress of the housing credit developments and making this consent agenda 239 items thicker. So we don't want to do that. And so to promote the efficient processing of these requests, this resolution would temporarily delegate the authority to designated staff to consider, grant, or deny requests for waiver or variance of this rule. This authority would expire when the rule is rescinded or amended. Also, going forward, the new RFAs coming out will include this option. So this is affecting people in the pipeline who want to take advantage of this change in the law, and we simply need to do some paperwork to make that happen.
Okay, thank you. Do I have a motion?
Second.
Have a motion and a second. Let me just make a comment that I have requested the staff to provide us as an informational item at each meeting how many of these they've processed between meetings, just so we know kind of how many take place if this motion passes.
Hopefully not 239.
Hopefully not 239. I kind of like carrying the big book. You know, I have to work out as much. So. Okay. We have a motion and a second. Any other comments or questions from the board?
I just wanted to say one more thing, that if we do see one of these requests that is unusual in any way or not the standard, that we would bring that one to the board if we felt it necessary. So we can still do that if we need to.
Right. Okay. Thank you. I think this will expedite the processing a lot, so thank you. All right, we have a motion and a second. There's no further discussions. All in favor?
Aye.
Aye. Any opposed? Okay. Thank you. Item C. I guess we're at item C.
Item C is the matter of Madison Oaks and American Residential Communities versus Florida Housing and the listed interveners, as well as Sterling Terrace versus Florida Housing and the listed interveners. This case arises from RFA 2017-111, tax credit funding for small and medium counties. In May of this year, we posted notice of our intended decision to award funding to several applicants, including interveners HTG Creekside, HTG Sunset, and Harpers Point. The board found that Madison Oaks and Sterling Terrace had satisfied all mandatory and eligibility requirements for funding, but awarded funding to the interveners based on the ranking criteria in the RFA. Madison Oaks and Sterling Terrace filed petitions. Several other challenges were also filed along with this, but eventually all challenges except for the petitioner's challenge here to HTG Creekside, HTG Sunset, and Harpers Point were dismissed, leaving only those two cases. The issue in this case, one of the issues in this case, is whether Florida Housing's determination that the applications of HTG Creekside, Sunset, and Harpers Point were eligible within the bounds above. If one of these applicants had been deemed ineligible, then a development named Claremont Ridge would be selected for funding. If two of them are knocked out, Sterling Terrace would also be funding. If all three are found ineligible, Madison Oaks would be funding. And we have representatives from all those parties here to talk to you today. Prior to the hearing, based on information we got in discovery, Florida Housing changed its initial position regarding HTG Creekside and Sunset and agreed with the petitioners that each of these applicants had incorrectly been awarded points for their proximity to a public school. One was a charter school, one was a magnet school. In one case, the judge found the charter school to be acceptable. We disagreed and I think Florida Housing has filed an exception on that. In the other case, she found the magnet school to be ineligible. We agreed with that decision. In both cases, I believe the problem was the criteria for entrance to that school involved a lottery and was not primarily based on geographic proximity. Another issue in this case is an easement. Madison Oaks has alleged that Harpers Point has an easement bisecting its property and argued to the administrative law judge on that issue. The administrative law judge disagreed and found that it was not an easement in fact that bisected the property. They have filed exceptions on that and also plan to address the board. The staff recommendation for this is to adopt the findings in fact and conclusions of law of the recommended order, except for the ones filed by Florida Housing. That would be a replacement of paragraph 63, a replacement of in note 13 to paragraph 64, and the rejection of paragraph 65 for the reasons that Florida Housing put in its exceptions, and Mr. McGuire will be able to answer your questions on that.
Okay, thank you. Do I have a motion on this one?
So moved.
Second.
I have a motion and a second. All right, I understand there are some other people who would like to talk about this one.
There are 17 attorneys on this case. I don't think all of them are going to talk
2 minutes.
today.
2 minutes each.
I don't think all of them are going to talk.
Okay.
I'll go first.
Okay.
Once again, please state your name so she can get it on the.
Yeah, this is Chris McGuire again for Florida Housing. I think it's going to be easiest. I think I've talked to the attorneys to sort of divide this into two parts. We'll talk about the schools first, and then all parties can discuss that, and then we'll go ahead and talk about the easement, if that's okay with you guys.
Yeah,
Sure.
That's fine.
Okay. Okay. Let me address Sunset Lake first. Sunset Lake, their application included a magnet school, the Jewett School of the Arts. The evidence in the hearing was very clear that geographic proximity was not a primary admissions or principal admissions criteria. And that matters because a public school is defined in the RFA as a public elementary, middle, or junior or high school where the principal admission criterion is the geographic proximity to the school. That's the first sentence, and that's all that matters for this magnet school. The evidence was there. There was testimony from the administrator of the school who said, no, geographic proximity is not a principal admission criteria. Lottery is a principal admission criteria. So there's a fact that the administrative law judge found, and that rendered this magnet school not a public school. There's lots of other evidence one could consider, but because there was competent substantial evidence to support this finding, I don't think that we can overturn that. In the second case, the magnet school, or the charter school, is a little more complicated because the definition of a public school goes on after the first sentence about geographic proximity and says this may include a charter school if the charter school is open to appropriately aged children in the radius area who apply without additional requirements for admission, such as passing an entrance exam or audition, payment of fees or tuition, or demographic diversity considerations. Let me talk for just a second about why we give points for schools. in the RFA, in order to be competitive, you have to get enough points for proximity to various different services. One of those services can be a public school. And the point of all that is, if residents move into this new development, and there are grocery stores, there are schools, there are hospitals that are close by, that's a benefit to the residents because they can use those services. A public school, we require the geographic proximity to be a principal admission criteria because if there's a school nearby that the kids who live in the development can't go to, there's no point in awarding proximity points for that. It doesn't benefit the kids in the development. So, the administrative law judge found that the charter school that was included in Oaks at Creekside's application did not use geographic proximity as a principal admission criteria. It seems like that would be the end of that. She also found that it did meet the second part of the definition as far as the specific requirements that apply to charter schools. Said it's open to appropriately aged children in the radius area, et cetera. So it met half of the definition. And then in the recommended order, she said that Florida Housing's interpretation, which is that charter schools have to meet both the first and the second sentences. They have to have geographic proximity as well as the additional requirements for charter school. She said that that interpretation was clearly erroneous because it violated the plain and unambiguous meaning of that definition. And she did this by explaining that what the definition really says is that the first sentence only applies to traditional public schools. Well, if that's true, then her interpretation makes sense. But that word is not actually there at all. She made that word up. The definition applies to public school, all public schools. Public schools include charter schools. So it's our view that the ALJ's decision that our interpretation was clearly erroneous can't stand up because it's based upon language that's just not there in the definition. She also discussed at some length Chapter 1002.33, which is the charter school statute. None of these arguments were ever raised below. The statute was certainly mentioned a number of times, but there was never an argument that said charter schools can never meet the geographic proximity requirement, which is what she thinks that this charter school statute says. Maybe it does, maybe it doesn't, I don't know. It's not our area of expertise. There are certainly parts of that statute that suggest otherwise. But the fact that nobody argued it and that we don't have any jurisdiction to interpret that statute anyway, to me, says that her argument shouldn't hold up. It doesn't matter anyway because our interpretation still says geographic proximity is required. Now, we had testimony that said we never say that charter schools can't meet this. There's no prohibition on charter schools. This is not a school choice issue. This is not a big policy issue. This is a case of, does this school serve the residents of the development? In this particular case, there was evidence that it did not, and that's where we are on that. Thank you.
Okay, let me ask you this. So the administrative law judge basically says for the charter school, it's okay to meet one of the two requirements.
To meet the second sentence and not the first sentence of the definition, yes.
But for the other school, they have to meet the first requirement. But the charter school doesn't have to meet the first requirement. Is that what?
That's what she says.
Basically what
She said the magnet school has to meet the first sentence, the charter school has to meet the second sentence.
That's interesting. Okay, thank you. Other questions for staff?
On the magnet school, you made a statement of that because of the lottery, I guess these kids in the development would not be able to attend. Magnets are public schools, right?
Magnets are public schools.
Okay, and so how do we know that, they won't make the lottery?
Well, we don't. We don't know that they won't make the lottery. It's entirely possible that some of the kids from the development might be able to go there, but many of the kids probably would not be able to go there. So the whole point of having a geographic proximity is to say this school is available to all the kids that go to that development. So a magnet school might take some of them, it might not take some of them.
Okay, thank you. Other questions from the board for Mr. McGuire? Okay, sir, you're up. Again, please state your name.
Good morning. My name's Craig Varn. I'm here on behalf of Sterling Terrace Limited and Sterling Terrace Developer, the petitioners. I'd love to sit here and tell you how genius I was in my proposal, but instead I'm just going to refer to Mr. McGuire and Florida Housing's exceptions, and that's based upon the testimony of Ms. Button, and that was simply that The undisputed testimony was that Florida Housing interprets the RFA as requiring any public school to meet the requirements of the first sentence of the definition of public school, and that is geographic proximity must be the principal admission criteria. So that being said, we deposed, took the testimony of the administrators from both schools who said quite simply, geographic proximity is not. I'd be happy to sit here all day and dispute and argue. I get paid by the hour. I'd be happy to sit here and discuss what criteria is applicable, what eligibility items are applicable, but the bottom line is the testimony was undisputed that principal admission criteria is not geographic proximity. At that point, I believe the discussion can end and we can all go home. So given that, I would simply recommend and ask that the board accept Florida Housing's exceptions and enter a final order.
Okay, thank you. Just for information, we're paid by the hour too up
Okay,
there.
great.
A little bit different wage, but okay, next. Thank you.
Chair, Maureen Doughton again, and Mr. Rieger, who is the principal for Housing Trust Group, has asked to speak on the issues of charter of the school issue, and I'd ask that he be allowed to permitted to respond.
Sure, thank you. Yeah, just like karaoke. Get up here right there at the mic.
Chair, thank you for providing me an opportunity to speak this morning.
Please state your name and your...
Yeah.
My name is Matthew Rieger. I'm the principal of Housing Trust Group. Being up here in front of you only reconfirms the decision I made back in 2003, and that's to stop practicing law. This is nerve-wracking. Board, I've been in this business for 17 years, and while you've no doubt seen me around, today is the first time you've seen me in front of you to speak about a matter that is personally important to me. Florida law is clear. Charter schools and magnet schools are public schools. And the state of Florida and Florida Housing must be consistent with Florida law and cannot arbitrarily overlay additional requirements which inhibit school choice. In the last 3 application cycles, Florida Housing has funded at least 5 new developments which used either a charter school or a magnet school as a public school. Clear and unambiguous precedent has been set and has been relied upon by HTG and, frankly, every other development company in this room and the state of Florida. In fact, the petitioner in this matter used the exact same type of charter school in the 2014 application cycle for their Denton Cove application in Franklin County. Amazingly, this same petitioner now argues on the record that this type of charter school is not a valid charter school. The Oaks at Creekside is a 96-unit development that's proposed for families in Manatee County, and they selected the Manatee Charter School as their public school. At DOA, Judge Van Wyck determined that the first sentence of the public school definition is inapplicable to charter schools. She gave 2 reasons. First, she said from a plain and unambiguous reading of the language, the first sentence does not apply to charter schools since they are only mentioned in the second sentence. And second, and I'm paraphrasing here, she says that the notion of geographic proximity to the school is contrary to the entire purpose of school choice. In fact, Judge Van Wyck stated, and this is a direct quote, Florida Housing's interpretation would effectively prohibit any charter school from qualifying as a public school under the RFA. Indulge me for a second and forget everything else you've heard about this matter and listen to a few simple facts. The Manatee Charter School is open to appropriately aged children in the Manatee School District, which the judge determined is the radius area. 2, there are no additional requirements for admission for students who want to apply. There's no entrance exam, there's no audition requirement, there's no payment of fees, and there's no demographic or diversity considerations at all. Florida Housing has repeatedly accepted charter schools as meeting the public school definition in other RFA cycles, and there is no reason to take a contrary position now. To do so would be unfair and contrary to the well-reasoned decision of an independent third party, which is upholding the original decision of your staff and this board to award funding to Oaks at Creekside. And I know, Chair, there's a limit on time, but I'd also like to speak about Sunset, which is a different application. Thank you.
You still have some time.
Sunset Lake is a proposed 96-unit development in Polk County. They identified the Jewett School of the Arts, a magnet school, as their public school. Polk County is divided into 4 magnet school zones. The process for enrolling your child in a magnet school in Polk County begins with an online application which requires the prospective student or their parent to input the student's address. This simple first step does 2 important things. 1, it determines what magnet school zone the child resides in. And 2, it then determines which magnet schools the child can apply to, because the prospective student can only apply to the magnet schools which are in their magnet school zone. This requirement for a magnet school to be considered a valid public school is clearly stated in the definition of public school. The principal admission criterion must be geographic proximity to the school. We all agree about that. The ALJ found, however, that the Jewett School of the Arts, the magnet school selected by HTG, did not meet the public school definition because she determined that, quote, geographic proximity to the school is a threshold issue which qualifies the students to apply. We do not disagree with the ALJ that geographic proximity is a threshold issue which qualifies students to apply. We only humbly offer that threshold is also clearly and unambiguously the principal admission criterion, since you can only apply once you've completed this initial step. Any inconsistency here is nothing more than semantics. Threshold versus principal. To penalize Sunset Lake due to a difference in interpretation between 2 words, threshold and principal, would be unfair and inconsistent with Florida statutes which clearly view magnet schools as public schools. Thank you.
Thank you. All right. Questions from the board for these gentlemen? Seeing none. Ron?
Yep.
Get very close to the mic, please.
The definition of public schools you gave us, would every person within this community or every child within this community be able to go to either of the other 2 schools?
Either of which other 2 schools?
Either a magnet or a charter school?
First of all, not every, I mean, we don't require that there be K through 12 right next to the school. So not every child can go to whatever the school it is.
Okay.
If it's an elementary school, certain age children would be able to go. If it's a traditional public school, if you will, which they have zoned areas, then all of the kids at that development who qualified for, who were the right age for it, would be allowed to go to that school. With a magnet school, they will accept students from really anywhere in the state. Their radius area is that county, but it could be, their school choice basically says anybody can go to any school if you can provide the transportation to get there. But they don't have to take the kids who are in this development. If they are oversubscribed, which they may or may not be in the future, then they will go to the lottery system to decide who can get in, and so that the kids in the development, some might get in, some might not get in. Charter school is the same way. They'll use a lottery system and other various things. Some of the kids that go to the development may be able to go there, some won't.
And public schools accept or have special classes for children with learning disabilities. Would that be the same in a charter school?
Does a charter school have classes for students with learning disabilities? I don't know. I'm assuming
Okay.
some do. But
I'm just saying that some people within this community, some of the children may have those issues. And I guess why I'm bringing this up is maybe we need to do something with our definition.
You know, every time there's litigation like this, it makes me want to do something about our definition. Because if it's not clear, if it's so clear that all these lawyers and clients are spending this much money to figure out what it means, then yes, I agree that we need to clarify it. And again, the point of it being, you get proximity points if you benefit the residents of the development. And that's, if we didn't word it properly, then that's what we want to spell it out that way.
Okay, thank you.
Thank you. Any other questions?
I do have one.
Yes.
Is there an explanation to his claim that on some applications you have allowed a magnet, and in this case you have not?
Yes. I'm glad you asked that.
Thank you.
When we get applications in, we basically take the applicant at their word. If they say that this is a public school and that it's within half a mile, et cetera, we assume that they're correct, because we know that if they're not correct, there's a whole lot of other people here with a lot of money who are going to go after them and demonstrate that they didn't do it correctly. We have never had any litigation over whether a charter school or a magnet school or maybe there have been some about public schools, but never about charter and magnet schools, not in the past several years anyway. We have not had any litigation. So it's never been brought to our attention that this school may not use geographic proximity as a principal admission criteria. If it were, I assume we would act the same way. So, and there was plenty of testimony about this. This question was raised at the hearing, so that the ALJ was able to also consider that. But we've never made a determination before that I know of that a magnet school or a charter school is a public school, even though it doesn't use geographic proximity as a principal admission criteria. We've never said that.
That's not in our definition, or it is?
That is in the definition.
Is.
Yes. The very first sentence, public schools have to use geographic proximity as the principal admission criteria. All public schools. It doesn't say all, it says public schools.
Chair, if I may make 2 points.
Yes, sir.
One, I think I conclusively proved that both the charter school and the magnet school qualify as public schools when you look at the definition. And two, he's correct. It's never been challenged before, but it was challenged this time, and an independent third party reviewed this and said the Manatee Charter School meets the definition.
Thank you, sir.
Go ahead. So my understanding was the magnet school was the issue, right?
There were two issues.
Okay.
There was Mr. Rieger has two applicants that were selected for funding.
Okay.
Sunset Lake and Oaks at Creekside.
So
Sunset Lake had a magnet school. The ALJ said that one did not qualify. Oaks at Creekside had the charter school. The ALJ said that one did qualify.
Other questions? Is there anyone else out of the 17?
Please, no.
Okay. If there are no further comments, you have one, few?
Well, you can't vote yet. Right. We have the other issue.
Oh, okay.
So this will be the end of the school issue. Now we go on to the.
Okay. Thank you for reminding me.
So on the next issue on easements, I think we'll let the Harpers Point people go first as they filed the exceptions. That's okay with you?
Yes, that's fine.
Charts and graphs.
Yeah, easier to think about.
Thank you.
Glad he's got the chart in here. Okay, we ready? 3 minutes left. Go ahead. 5 minutes. Go ahead.
Thank you very much. My name is Doug Manson.
You'll need to get close, Doug.
Is it working?
A little really
Okay.
close.
My name is Doug Manson, and I represent Madison Oaks. And we're here, obviously, on our exception to a rule.
Yeah,
Even
really
closer?
close.
Okay. All right. So my name's Doug Manson, and I'm here representing Madison Oaks, and we're taking exception to the recommended order. And our position is this: we got in this case down to one issue, and our issue was on Harper's Point had been selected for funding, and it's whether or not Harper's Point had an undisclosed scattered site. And the definition of scattered site in relevant part, it's at your Rule 6748.002105. And the only part at issue here is about the easement, so I'm revealing that part. Real property is contiguous if the only intervening real property interest is an easement, provided that easement is not a roadway or street. So when you break it down, we've got to go to the corollary. You know, what is the easement for? In the Florida housing interpretation prior to hearing, at hearing, and post-hearing, and the proposed recommended order is that whether or not the easement is for a road or street rather than for like a utility easement or something of that kind. And so we go down and what I've passed out to you is Exhibit 6 and 5. And
I'm sorry, but I need to say something real quickly here. This document was not admitted into evidence.
that document you have in your hand is admitted into evidence. That's Exhibit 5 and 6.
Mr.
One
Chair,
is printed on a Pilar and one is printed on a piece of paper. Those are two exhibits that were admitted into hearing.
Doug, I understand that the boundary survey of the underlying paper was admitted, but I'm not quite sure that this overlay was admitted. I understand it was objected to. and
This is
not
Exhibit
admitted.
6 and Exhibit 5. 5 was the site plan, and it was accepted into evidence, and it's printed on the Mylar.
And so you're just
Yeah,
combining
I'm just
it.
superimposing
Okay.
two Mylars on top of each other. That's two exhibits on top of each other. I could do the same thing with a light table or with an exhibit, but instead I did it more primitively since I'm not as familiar with IT.
So if you take off the plastic piece, for example, this was admitted as evidence, right?
Yes.
This piece of paper here.
Yes.
I recommend that that's what you look at, is the evidence that was
No,
admitted.
sir. This also is exhibit as evidence. The Mylar is exhibit. One is Exhibit 6, the other is Exhibit 5. Both were admitted into evidence. 5 and 6, petitioners' exhibits 5 and 6 were admitted into evidence.
Mr. Chair, I think it would be best if we let Mr. Manson continue and let the attorneys for the other parties talk about this evidentiary issue. If it does turn out that one of these is not in the record, and I'm sure somebody will be able to find that one way or the other, then you would not be able to consider it here. But I'll let the attorneys argue about that.
All right.
Okay. Thank you.
I did not believe this was controversial. Sorry, Exhibit 5 and 6. I'm using this simply
Is
for the.
that site plan, I'm sorry, is
This
that
is-
site plan admitted? Because it's the same, it's just.
It's
done
not the
together.
it's not the same thing as 5 and 6 because it shows a DLP point, but other than that, it would be yes. So the only thing that I was using this for is just a demonstration of where is the bisecting easement. The yellow line you see is the bisecting easement for the property, and the definition of an easement is obviously a property right. The very beginning of the hearing, and I'm hurrying up now. At the very beginning of the hearing,
I paused it while y'all had that
thank you very
discussion going on. Go ahead.
Thank you very much. So the very beginning of the hearing, both Harper's Point and my client, Madison Oaks, we had experts testify about real estate, easements, plats, and the judge found in two corresponding motions in limine, she didn't have jurisdiction to determine the adequacy or the legal validity of a plat or an easement because she's not a circuit court judge, and that's exclusively, property and title issues are exclusively in the bailiwick of the circuit court. So they're not here with Florida Housing, they're not with DOA. So no evidence was put on as to that. The parties stipulate, and I'll pull what Mr. Glazer did here, and I'll show it to the parties. It's a line out of the recommended order and a line out of the response. Yes, I understand. So this is just two lines out of the one's out of the recommended order, and this is what we're relying on. It's finding of fact number 41. Harper's Point's proposed development site is identified in its site control documents, consists of land located within a platted tract of property. The plat recorded in Alachua County indicates that the site is bisected by a platted 50-foot street easement running east and west through the property. And then Florida Housing responds to petitioner's exceptions, that's our exceptions, states correctly, it was stipulated by the parties that an expressed easement exists on the property, that it bisects the property, and that it was labeled as an easement for a street. So what this case actually comes down to is the interpretation of scattered site. The Florida housing interpretation is whether or not the easement is for a street. It's adding in the word "for" to the definition. I believe, although it's not clear in the hearing officer's interpretation, she never states it, she goes around it, but the bottom line is she is interpreting that statement to mean there has to be an actual physical street constructed on the easement property, which is clearly not the way the rule should be interpreted and not the way it has been interpreted in the past. So what we're asking you to do is recognize what was stipulated to the parties, that it's an expressed easement, that it bisects the property, and that it's an easement for a street. And by doing that, it is, in fact, a scattered site. So we're asking you to overrule the hearing officer. All of her findings of facts regarding the construction issues in the streets, I don't have any problem with them. They don't basically have anything to do with the easement being for a street. But she does have two findings at the end, which are actually masquerading as findings. They're conclusions of law. And she's implying the interpretation of the rule, her interpretation, although implicitly, because she doesn't say it, she says, all the evidence shows me this isn't a scattered site. It is a scattered site under the definition and interpretation of Florida housing. Now, one of the issues that may have come up at the hearing, at least implicitly, or perhaps because it's impossible to tell what was in her mind, she doesn't state what her interpretation is in the rule, nor does she find Florida housing's interpretation is incorrect. But I'm wrapping up. In the definition in your RFA 2017-11 that's adjoining Exhibit 1 at page 106 and 127, says if it, underwriting, this is why this is important, it's important at the date line of the application as well. If the applicant indicates the proposed development site does not consist of a scattered site, but it is determined during credit underwriting that the proposed development does meet the definition of scattered site, all the scattered site requirements must have been met as of the application deadline. And if all the scattered site requirements were not in place as of the application deadline, the applicant's funding award will be rescinded. I mentioned that just simply to say scattered site as part of site control is an essential element. It is a mandatory element, and it must be met. And this applicant, although the hearing officer erroneously determined he did, it is not a scattered site. It is a scattered site. And I would ask you to overturn those and grant our exceptions and issue the ruling.
Thank you. Could you remove that first thing and let me look at just the map again? Yeah, even with my glasses, this one.
Okay, I know. That's why I brought this one. It wasn't perfect. Okay, the easement is shown in kind of a purple across there, right? That's correct. What is that the purple that goes north and south? That's a north-south easement, but it doesn't bisect the property, so it's not considered for development of the site.
So it's, does it say it's a street easement also?
Yes, sir. It says the same thing. It's a 50-foot or 60-foot street easement on the survey.
But right now, it's not there as far as there's no street on any of those, right?
Well, the findings find that there is some evidence of some construction to some degree, but it's not a passable street. It has It has a boundary at the top there. I've seen a blockage at the top where the city's put up pylons. I'd also say to you that I don't put the site plan up there to say that this is somehow going to block their development. Right. It was just simply to show you where the bisecting easement is. I realize that site plans can be altered in underwriting.
And this question is probably more for our staff. If they had checked the box, it said it was a scattered site, would that have made any difference on the selections?
I believe that it would, but I think Mr. McGuire is going to address that more specifically, but that is the issue.
Check the box and nothing else. Chris McGuire. If they had just checked the box and done nothing else, that would not have been enough. There are a couple of requirements that they have to meet as a scattered site that have to give specific latitude, longitude coordinates for each of the separate scattered sites, so they'd have to identify that the development location point was on the site with the most number of units. But that's the only significant change. It would not have been a complicated thing to make that.
Okay, thank you. Other questions?
What did the ALJ conclude with respect to this easement? I'm a little confused.
The ALJ concluded that even though it was labeled as an easement, it was, as a matter of fact, not really ever going to be a road, and she essentially found that it was an easement in name only.
Because it's not physically open.
Yeah.
Right? And those 7 lots to the west, are those existing single-family homes?
I couldn't hear the question. I'm
sorry.
sorry.
7 lots to the west, are they
again,
single-family homes?
And I think council is going to agree with me. The site plan itself can be altered So it wasn't so relevant in the proceeding of what was going to be hit by the bisecting easement, just simply that it did bisect the property. That was it.
Okay.
And I guess following up on Barney's questions, if those are homes along the west side over there, the chances of that ever being used as a road is going to be slim.
It's a road to nowhere.
Yeah, to the backyard of somebody's backyard.
That's right.
Okay. Yes, sir. Go ahead, please.
Thank you, Mr. Chair. Excuse me. Thank you, Mr. Chair and members of the board. David Weiss on behalf of Harpers Point.
I'm sorry, that microphone's not picking you up. Can you please?
You got to practically swallow it. Excuse me. Is that better?
Yes.
Can everybody hear me? Thank you. David Weiss on behalf of Harpers Point. I think you picked up on something that's very important that I'm going to address in my presentation. I do appreciate the opportunity to speak, and I will try to make this brief because I know you've already been here for a little while and have a full agenda. But I think it's important to remember that Florida Housing was did select Harpers Point for an intended award. The administrative law judge found, after hearing all the evidence in this proceeding, that the petitioner failed to carry its burden and that the intended award was correct. Florida Housing staff and council recommend that you do deny the exceptions and enter a final order adopting the administrative law judge's recommended order with respect to Harpers Point. Really, this one's pretty easy. It's not the role of this board to reweigh the evidence, substitute its judgment for that of the ALJ, or consider new evidence, which is not part of the record. With respect to that comment, the board that's been presented here today is not record evidence. What you have, and I think what council has told you, is two exhibits, and the overlay is not part of it, but I think we can kind of ignore that because, as council stated, the site plan overlaid on top of the survey really has no relevance. There's nothing that restricts Harpers Point from changing its site plan. So I think we can pretty well ignore that. Since we are looking at this survey, basically you can see what the survey says. It identifies an easement area, and it identifies it as a 50-foot street, not physically open easement, and then it references a book and page. So what counsel for Madison Oaks is telling you is that he's representing that the ALJ found and that the parties agreed that this is a street easement. When in fact, that's a complete mischaracterization of what the ALJ found and what the parties agreed. What the ALJ found and what the parties agreed is that there is a recorded plat that identifies streets, paper streets, and there's an easement that refers to the easement area as an ingress and egress easement over the streets as identified on the plat. That's all that the finding was. The finding was no more than that. It was not a finding that there is, in fact, a street easement. In fact, the finding was the complete contrary. The sole issue here is whether this easement is a roadway or street. Roadway and street are not defined terms. The Florida Housing corporate representative testified that there are numerous factors that Florida Housing will consider when determining whether or not an easement is in fact a roadway or street. The only factor that weighs in favor of finding that this is a roadway or street is the label on this survey. That's the only factor. All of the other factors weigh in favor of finding that it is not in fact a roadway or street. There is nothing on this site that remotely resembles a roadway or street. There are physical impediments which prevent access and use. Specifically, there are findings of fact that state that the area is heavily wooded and it's sandwiched between a fence and a developed residential subdivision. There are single-family lots over here on the west side that are developed, and a man-made berm on the eastern end. So, as I think the board has pointed out, even if something that could resemble a roadway or street could be built, it would be a road to nowhere because access and connection are prevented on both sides. So essentially, the argument boils down to this. It's called a duck, so it must be a duck. However, the flaw in that argument is it doesn't walk like a duck, it doesn't talk like a duck, it doesn't remotely resemble a duck, and even if it's an egg, it's not something that could ever actually be a duck. So, again, going back, in this proceeding, the findings of fact in the recommended order are supported by competent substantial evidence. The conclusions of law are reasonable and necessarily follow the findings of fact. And we respectfully request that you follow Florida Housing's staff recommendation and council's recommendation to deny the exceptions and enter a final order that adopts the recommended order with respect to Harpers Point. Thank you very much, and I'm happy to answer any questions.
Thank you. Yes, Ron.
Now, this easement, was that on a recorded plat? What put it there?
The easement, there is a plat that was recorded back in the 50s or 60s, and it identifies these streets, for lack of a better word. This plat, and actually the parties all agreed that these streets were never dedicated, that it was never something that was accepted by the city. So they are paper streets, and then there is a deed which includes a reference to this easement area as the streets over, as an easement over the streets identified on the plat. So it's a convenient way to describe the easement area, but it's not, in fact, a street. It's just a convenient way to.
Okay. And there's no requirement to vacate that easement?
That's correct. It was not, again, the parties agreed that these streets were never dedicated, therefore there would be no requirement to vacate them.
Okay.
So Alachua County or Gainesville or any city, wherever it's at, they don't claim ownership of that easement?
I'd like to address the last question briefly.
Okay.
Just the
Yeah,
idea
go
we haven't, just your representation that we've agreed. We were precluded from putting on any evidence, and so were they, to the validity of the easement or the plat, because that's beyond the jurisdiction, the hearing officer ruled, to be able to discuss at the hearing.
Okay.
So right now, they've identified that it's on a plat, just like he said. And the easement shows on a plat and it shows on another deed. I agree with that. But the issue of whether or not it would have to be vacated before underwriting hasn't been determined. That's something that would have to go on later.
Thank you. So does anybody claim ownership of the easement? County, city?
No.
Okay, thank you. Other questions from the board? We got one more to speak?
Yeah.
Oh, okay.
If I might. It won't take long, and I will not talk about ducks. This is Chris McGuire again for Florida Housing. I want to first agree with Mr. Manson when he said that the recommended order is not as clear as it could be. I think that we would all agree that you have to imply some things in there because she's not really clear exactly what she's saying in this. But she finds in Finding of Fact 41, and that's, I think, on his little piece of paper there, that if the platted street, that the plat indicated that the site is bisected by a platted 50-foot street easement, right? That's not a finding that it was a street easement or that it was an easement for a roadway or a street, just a finding that the plat indicated that it was. She also found in 46, she said, if the platted street is a roadway or street, as those terms are used in Rule 6748, then the site would meet the definition of a scattered site, and that has been Florida Housing's position all along, too. We don't dispute that there's something called, that there's an easement of some kind out there. It may be called a street. The question is it a roadway or street as defined in our rule? Well, not as defined, as used in our rule. We don't define the terms at all. And since she found that the property is not a scattered site, the clear implication, which she doesn't spell out, but the clear implication, I think, is that the ALJ found that the platted street is not a roadway or street as is contemplated in our rule. Now, we had testimony that if it looks like when we look at the documents that we have received and it says it's a street easement.
Were you just going to use the duck?
I'm sorry?
No.
No ducks. Right. We had testimony that said if there's documentation that this is a easement for a street, then we'll assume that it's true that it's a scattered site. But we'll also be able to consider other things to decide whether or not it's a scattered site. It's not just looking at one piece of paper. And so our witness testified that there were a number of other factors that she would consider, whether it had actually been built, whether it could be used, whether there were impediments to its use, that sort of thing. And so what we did not have was just one piece of paper that said, this is plat, it's a street easement, we're done with it. There was a lot of other evidence that was considered. And what that evidence showed, as you've heard, is that this is basically a road to nowhere, and it's just never going to be used. It's a road. There are too many barriers to it. It doesn't go anywhere. So whether or not the easement remains valid was never disputed. No one could ever prove or not prove that the easement's valid. That's not really the point. The point is this easement something that is a roadway or a street that would cause it to be called a scattered site? Now, we have different reasons for what we would consider a road or a street than maybe real property law would. The whole point of the scattered site is that if you have two sites that are separated somehow so that you can't access one to the other, then you don't want to have the swimming pool that the kids have to cross I-10 to go swimming in. We want you to consider all that and to talk about it if there's an actual impediment. So a street or a roadway that, if it was a small bike path, we wouldn't necessarily consider that to be a street or a roadway for purposes of scattered site because it doesn't make any difference in the end. So I guess all we can assume here is that from the ALJ's findings, you have to deduce that a roadway or a street, even though it was never defined by anybody, at least has to be accessible to traffic. It has to be useful for something. It has to create some kind of a barrier between the two parcels, the north and the south parcel. And that's a reasonable interpretation of street or roadway. There was no other conflicting definition. And I think that the administrative law judge's conclusions, vague as though they are, should stand.
Thank you. Any questions from anyone?
Again, to recap, back to Barney's question, the administrative law judge agreed that it was not a road.
The administrative law judge agreed that it was not a scattered site.
A scattered site, thank you.
Yeah, she never said it's not a street or a road. She never said it is an easement or not an easement.
And the application was not submitted as a scattered site.
That's correct.
Okay.
Okay, Mario?
So we're going to be voting on this in a second.
Hopefully.
So there's two things going on here. There's the schools and there's the scattered site, correct?
That's correct.
All right. So but this is all one vote. Are we breaking this into two parts, or?
It's one vote because you have to eventually come up with one final order on this.
Mm-hmm.
So that has to be, I think, one vote on that. You could vote separately. You'd have to have ultimately a vote on all of it together, though.
I gotcha.
The motion, I believe, is the recommended.
Motion is
correct.
Combined. So
the recommended order, which is one school is considered a public school, the other school is not, and the easement's a non-issue, or not a scattered site.
That's correct. The magnet school is out, the charter school is in, and it's not a scattered site.
Okay. How would it be impacted if we agreed both schools were in or out, either way, and the scattered site is, as administrative law judge said, how would that impact the motion?
Okay, if the recommended order as it is says only Sunset Lake is ineligible, that means that Sunset Lake won't get funded and Claremont Ridge will get funded. I assume somebody is here from Claremont Ridge, but they don't have really a dog in the fight, or a duck in the fight. So if the recommended order stands, Claremont Ridge gets funded instead of Sunset Lake. If Oaks at Creekside and Sunset Lake, the two schools, are both ineligible, then Claremont Ridge and Sterling Terrace get funded. And if both of the schools are ineligible and it's a scattered site, Harpers Point's a scattered site, then Harpers Point's not funded, and Claremont Ridge, Sterling Terrace, and Madison Oaks get funded.
And what's the staff recommendation again?
I was hoping you would ask that because it's been a lot of talk. The staff recommendation is to adopt the findings of fact and conclusions of law in the recommended order with the exception of the ones, and to grant the exceptions filed by Florida Housing, which replace paragraph 10 of the findings of fact and also alter conclusions of law 63, 64, and 65, and in note 13 to paragraph 64. So the staff recommendation is to adopt a final order, adopting the recommended order with the changes suggested by Florida Housing's exceptions. That's the current motion on the table.
And those changes are
That change would make the charter school in terms of the result, it would make the charter school that the ALJ found acceptable, unacceptable
Unacceptable.
for the lottery reason.
And that motion was seconded? Was that motion seconded a while ago?
Yeah.
Yeah.
Okay.
So
Okay.
basically, both schools ineligible, staff recommendation, both schools ineligible, and the site is not scattered site.
That's the basic result of the
That's
recommendation.
the motion we have right now.
yeah. Yes.
Okay.
Other questions or comments? Okay, no one else to speak to this? So restate it one more time. The motion is that neither school is considered eligible.
The motion is
and
to
it's not
adopt
a
the
split
recommended
site.
order as a final order, with the exception of Florida Housing's changes that they suggested in their exceptions, with the result of both schools would be considered ineligible and the site would not be a scattered site.
Okay. Thank you. All right. If that's the motion, there's no one else to speak. All in favor of the motion?
Aye.
All opposed? Me?
Aye.
I'm opposed, aye. Opposed, aye.
Opposed?
Okay. I think I'm going to need a show of
All
hands.
right. Well, yeah, show of hands. All in favor?
I'm flying solo.
All opposed?
Then we will need a new motion.
Okay, so that motion fails. Is there another motion that someone would like to make? Can we split the thing up
That's
into
what
two
I'm
motions?
asking.
You can split it up into two votes if you want, if that's going to help facilitate it, but you could do it that way, if that's going to make it possible to get the votes out.
Chair, could I ask a
Yes.
question? I'm trying to make sure I'm clear on this. I thought we decided that the charter school was a school and that the magnet school was not.
That's what the administrative law judge said, right?
That is what the ALJ ruled. What Florida Housing's exceptions argued was that both of them were ineligible.
And
That
why do
motion
you
has been defeated.
Okay, and Chair, would you mind if they explain to me why they consider a charter school not a public school?
It was because it was a public school. Charter schools are public schools.
That's what I believe.
What the issue that Florida Housing had, if I'm speaking for Mr. McGuire here, I guess, is that it had a lottery requirement, and so the geographic proximity wasn't the primary consideration.
Thank you for that refresher. Sorry.
Okay.
Mr. Chair, can I address that issue?
If you'll state your name and address.
Craig Varn on behalf. The issue is, it's not a dispute, it's a public school. It's the definition in the RFA that Florida Housing has adopted. And that is the first sentence says geographic proximity must be the principal admission criteria. The factual testimony was it is not. So nobody disputes it's a public school. The dispute is how Florida Housing has chosen in this RFA to define how you get proximity points. So we all agree on that issue, and there was never in dispute. And I want to address one real quick thing. They pointed to my applicant had previously submitted a charter school. That's absolutely correct. The difference is this charter school does not use geographic proximity as its principal admission criteria. So it's a factual issue there. That's the distinction. We're not arguing it's not a public school as the grand term is used. It's just for whatever reason, Florida Housing chose to incorporate that definition, and that's what we're sticking with. Thank you.
Thank you. Yes, sir, you may respond.
If I may respond. Sure. My name is Matthew Rieger. I'm a principal with Housing Trust Group. The petitioner's charter school had the exact same admission requirements as our charter school. In addition, the charter school was ruled by the judge, an independent third party, the first time this has ever been challenged, to be a valid public school and meeting the definition of Florida Housing's public school. Thank you.
Thank you.
I have to. That is not factually correct. That's a misrepresentation of the facts. There's no testimony to suggest that the criteria were the same. So I just want to clarify that that is absolutely not true.
Okay, thank you.
We're going to keep going back and
No,
forth, gentlemen.
we're not going to keep going back and forth on it.
There's no need to go back and forth. He can claim it's not true. You believe who you want to believe.
Thank you. Okay, so is there anyone on the board that would like to make a different motion, or would staff like to proffer something?
Well, I left my telepathy helmet at home, so I don't really know what kind of motion you guys want to craft. The staff motion, again, was that both schools were ineligible and that the scattered site was not, the alleged scattered site was not a scattered site. Okay. The recommended order agrees with that up to the point, except for the charter school, which says the ALJ agreed that it was a charter school, based on the way that she read the definitions and the language. And I know Mr. McGuire addressed that.
I'd like to proffer a motion. Both schools be considered public schools in proximity definition?
They're both already public schools. That's
Right,
not a...
so,
yeah.
but for proximity purposes, and that it's not a scattered site.
Okay, is that...
I'm sorry, so your motion is that the Jewett School of the Art, the Magnet School, should be considered a public school, that it meets the definition of a public school in the RFA?
That's what the administrative law judge had, right?
No.
I'm sorry,
The
that was the
administrative law
opposite.
judge said that the Magnet School,
The other one, I'm sorry.
that the charter school
The charter
was a
school
public
be
school.
considered, basically what the administrative law judge had, which is the charter school be considered a public school for proximity purposes, the art school as not, and not a scattered site.
So your motion would be basically to accept the recommended order
By the
more or less
administrative-
unchanged.
Exactly. The administrative law judge's initial recommendation.
Second.
Okay, we have a motion and a second. I'm afraid to ask, is there any more discussion on this? Does anyone? Seeing no one, thank you. All in favor of the motion proposed by Natasha? Aye.
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 Any opposed?
Aye.
No, I mean, aye.
So 2 opposed. All right, but please do hands again. All in favor? 4 opposed? 4-2, motion carries. Thank you. Thank you.
We'll have to
everybody that
draft a final order
testified.
for you.
And I hope the duck doesn't get run over going on across 10.
I do this and great caution in the council, but I wonder if it would be appropriate, I would like to ask the board to ensure that they've had no contact from anyone regarding this case prior to coming into the hearing outside of your own counsel in this proceeding. To poll the board. Okay, I would like to have the board polled to reassure, to confirm that there's been no contact with the board from anyone beyond their own lawyers in this case between the time the recommended order was issued and our hearing today.
I have not even from our own lawyers, just what I read on this paper and what I've gathered from this
Thank you.
briefing. First time I hear about it.
Same here.
Yeah, same here.
Same here.
Same with me.
All right, the only person I talked to was Trey and our staff.
Right.
So,
That's perfectly okay. Thank you very much.
thank you.
Mr. Chair, I'd just like to apologize that I'm stepping in and out. I've got crews in North Carolina, and I keep getting urgent messages. I'm going to have to step out another 2 minutes, but
Totally understood. Thank you. Okay, moving on. D. Are we at D finally?
Good morning once again. The matter before you is Renaissance Point Apartments, LLC versus Florida Housing Finance Corporation and Midtown Lofts and HTG Rainbow. This case arises from RFA 2018-102, Housing Credit Financing for Local Revitalization. Renaissance Point, Midtown Lofts, and Rainbow all applied for funding through the RFA. They were all initially deemed eligible for funding. Midtown was selected for preliminary funding as the highest scoring application. Renaissance got the second highest score, but was skipped due to the lack of funds to be able to fully fund that application, which then rolled down to the third ranked application, which was HTG, and it was selected for funding. Renaissance contested the eligibility of Midtown, alleging that Midtown's incorrect response to a question regarding the occupancy status of the development rendered Midtown's application ineligible for funding. During litigation, Florida Housing, Midtown, and HTG maintained that Midtown's incorrect response to the occupancy status question was a waivable minor irregularity and qualified as such. A hearing was conducted earlier this month. The judge concluded that Renaissance failed to prove Florida Housing's decision to waive as a minor irregularity Midtown's incorrect response to the occupancy status question was erroneous. In other words, the judge agreed with us and recommended that Florida Housing enter a final order dismissing the protest. On September 7th, Florida Housing filed one exception to the recommended order. This is, I want to make sure everyone understands, an uncontested exception meant to simply clean up what we found was probably best characterized as some unnecessary speculation on the part of the ALJ. So other than that, staff recommendation is that you adopt the recommended order as your final order with the exception of the substitute conclusions of law in paragraphs 13 and 15 as proposed by Florida Housing.
I move staff's recommendation.
Second.
We have a motion and a second. Any discussion from the board? Any questions? Anyone in the audience? Okay. All right. If there's no additional discussion, all in favor?
Aye.
Aye.
Any opposed? Okay, very good. You have another one?
I got one more.
One more.
But it's not legal.
Oh.
I believe the next item on the agenda is professional, is it PSS?
Yeah.
PSS item A.
Yes.
Did we skip Sterling Terrace?
No, that was actually one, that should have been one item. C and D were together.
Oh, okay, gotcha.
Yeah.
Item A on professional services selection is the single source procurement for the housing project portfolio system. Way back in November 2001, Florida Housing entered into a contract with HDS to provide a housing project portfolio system to assist with keeping track of our funded projects. This was custom designed for Florida Housing and is only available from this vendor. This is the application we're currently using to do our fundamental tracking and management database stuff and has been in place for over 16 years now. Multiple business processes supporting these systems and depend on these systems. And so that's the current model we're using. At the May meeting, however, staff was authorized to enter into a contract negotiations with ProLink Solutions Incorporated. We expect that this new software will replace the old software that we're using. And so we're asking you to let us hold on to this HDS software during the transition period. They really are the only vendor who can give this to us because they built it custom for us. This is part of phasing out that old system and phasing in the new system. And we just need you to approve another one-year single source contract with HDS so we can accomplish that phase out.
Okay, thank you. Do I have a motion?
So moved.
And we have a second. The only comment I'll make, I did question staff is related to an escape clause on this. So if the new system is up and running quicker than the end of the 1 year, can we get out of the contract? And they affirmed that was included. So
Yep, 60 days.
60 days notice. So. All right, we have motion and a second. Are there any other comments? Seeing none? Yes, Ron, do you have one?
Can you say this without taking a breath? Single source procurement for housing project portfolio systems.
After he has a drink of water. Okay.
Single source procurement for the Florida Housing Project Portfolio System.
Yeah. Easy for you to say. Okay, all in favor of the motion? Aye.
Aye. Aye.
Any opposed? Very good. Thank you. All right. Hey, Nancy.
Good morning.
Good morning.
Good
Do I have
morning.
to turn this on? No.
No.
Can you hear me? Can you hear me? Can you? I'm here to talk to you about,
You got to be really
even
close.
me?
Yeah, you got to be really close on it.
Nancy Muller, Florida Housing Finance Corporation. So 3 developments were awarded pilot funding in 2014 to create developments of less than 50 units in 3 different counties to house chronically homeless residents who are high utilizers of public services because of their needs. All 3 properties are up and running. We've got one in Jacksonville, one in Miami-Dade County, one in Pinellas, and are fully leased. Each developer committed to hire a research team to carry out cost-benefit and personal outcome evaluations of how well this model works. Does it work? Does it work well to stabilize those residents? Does it save money across the publicly funded services, jails, emergency rooms, acute care services, the kinds of things that often occur for chronically homeless folks coming in and out of off the streets because their health declines, et cetera, over time. So data are being collected on the residents who are living in these properties over a 24-month period. And because of the importance of this research, what we're interested in doing at the end of this is that each property will submit their research report, which is really looking at costs versus benefits. And we will provide that information to Florida policymakers who've expressed some real interest in understanding whether this can be a way to save money. So because of the importance of the research, Florida Housing staff determined several years ago that it would be helpful to have assistance from a more knowledgeable organization to ensure that the sites are problem solving around data and research questions that arise. You can see from reading this item, this board item, that we've had help from the Corporation for Supportive Housing over 3 years now. This is a contract that's less than $20,000 each year, and they've been extremely helpful to the sites as well as to Florida Housing in thinking about this research. Last year, we went to a single source approach for this. A small contract because after seeking others with capacity to do this, we found that nationally the Corporation for Supportive Housing is not just the leader doing this, but really the only entity doing the work. So today we're recommending that it's in the best interest of Florida Housing to continue with these services and proceed with a new 1-year contract for 2019. And in full disclosure, we would come back to you for 1 more year, at which point we will be basically finishing this up. Staff requests authorization to enter into negotiations for a single source contract with the Corporation for Supportive Housing Incorporated for this purpose.
Thank you.
So moved.
Second. Motion and a second. Any questions?
I had a question
Yes.
for you, Nancy. In January 2016, did the collection of data for all 3 developments start then?
In January 2016.
Because it says that the initial phase of the work started in January. Basically, when did the
Yes.
actual 24 months
So
commence?
as the properties leased up and the first property completed its move-in in August 2015. So as residents moved in, the first phase of data collection for each resident was to collect as much data, go back for a year to figure out what their costs had been while they were living on the street during the year before they moved in. And then it will continue for 24 months of residency. So really it began in 2015 as residents started to move into the first property.
Okay, that was my question, because obviously we're well past the 24 months.
Right, and
So why are we?
Well, one of the reasons that lease up it's interesting. There's so much need out there, so you would expect that once each property was built, it would just be immediately full. And in one case with the property, that worked out very well. But for the other 2 properties, which took longer to get up and going development-wise, for the other 2 properties, and one in particular, one of the issues that sort of comes back around and belies that expectation is that if you are truly pulling off the street the most chronically needy people These are people who are often in their 50s and 60s, maybe older, but who have really aged. Their health is so poor that they are functionally 70 and 80-year-olds and whose health is in such bad condition that we actually had people move in who died in the first months. There were a couple times when folks said, I don't want to do this, and left, chose to go back on the street, unfortunately. So several of the properties had to keep sort of working to get folks to move in who, were in good enough shape to begin to become stabilized. So the last property, the Miami-Dade property, Coalition Lift, while that property was actually completed in April 2017, it took them more than a year to actually get all of their units leased up. So we're looking at the last property providing us its report in early 2021, but we expect that most all of the work and research, sort of the results and all, to be coming in more in the 2020 range, and so that's why we think we'll need it through then. But
Thank you.
This recommendation is just for 2019.
Yeah, 1 year. Okay.
Yes.
Thank you.
And we know that we're going to need it again next year, though, right?
Yes, sir.
2020. Is there something that prohibits us from going 2 years? Or just maybe they're not willing to do it for that?
Do you know if
Right.
there is anything single source for 2 years? No,
Yeah, which is
we don't.
very unusual for me to question because I usually don't think we ought to have
I know.
single source.
We don't usually like to do that, but it's true that we do need it for we believe we need it for 2 more years, and that it's relatively small contract.
All right, thank you. The motion on the floor is for the 1 year extension as proposed, and that's fine too. I was just curious on the other one as far as I'm concerned.
Chair, are we able to amend an up to 2 year?
We could do a different motion, I guess, if that's what the board feels like. Like I said, it was more a question I had for maybe even future ones that I may want to ask. But,
No, I had the same question.
I'm sorry.
Yeah, go ahead.
I like the 1 year just because then it reminds us, this is still out there.
Yeah, that's a good point. That's a good point, too. All right, so the motion on the floor is for 1 year, and it has been seconded. If there's no further discussion, all in favor?
Aye.
Aye.
Any opposed? All right, see none. Thank you, Nancy.
Thank you. And I'm up on the next one.
Okay.
This is contract renewal for technical assistance provider services for our pre-development loan program and demonstration loans and other programs as needed. At the October 2015 meeting, the board authorized staff to enter into a contract negotiations with 3 firms to provide these services. We did enter into contracts with each of the 3 who are listed, or which are listed in your item. And contingent upon satisfactorily performing obligations under those contracts, we may renew the contracts for an additional 3-year period. Florida Housing staff supports using the 3-year renewal option for all 3 contracts. So we're here today to recommend that the board directs staff to proceed with the 3-year renewal option.
Okay, thank you. Do I have a motion?
So moved.
Second.
A motion and a second. Is there any questions or discussion on this from the board? Seeing none, all in favor?
Aye.
Aye.
Any opposed? Okay,
Thank you.
thank you. All right, Kevin.
Thank you, Mr. Chair. Good morning, Board. It's Kevin Tatro. At the June 16, 2017 meeting, the Board authorized Florida Housing staff to issue a solicitation to procure 1 or more qualified firms to provide capital needs assessment services. In response to that, Florida Housing issued RFQ 2018-04 on June 18, 2018. 8 responses were received from this RFQ. Members of the review committee, consisting of Tim Kennedy, Ken Curitan, and Elaine Roberts, scored those responses and presented their findings in a review committee, which met on August 1st. The August 1st meeting of the review committee, members provided their final scores for their responses, and the scores are attached as Exhibit B to this presentation. The staff recommendation is to have the review committee recommend The review committee recommends that the board authorize Florida Housing to enter into contract negotiations with AEI Consultants, Clampett Industries, LLC, doing business as EMG, GLE Associates, Inc., Morin Construction Consultants, LLC, On Solid Ground, LLC, Partner Assessment Corporation, doing business as Partner Engineering and Services, Inc., and Varian Associates, PA.
So moved.
Second.
There's a motion and a second. Is there any discussion? Any questions? Seeing none, all in favor?
Aye.
Any opposed? Very good. Thank you.
Thank you.
Thanks, Kevin.
All right. Yeah. Now that we're at the consent agenda, Mario, you had some comments or you would like to make about some of the items or the
Yes.
form?
Yes. So in a number of the items, there's a waiver for the IRS Form 8821, which is basically for nonprofit organizations, for their board members who have no compensation coming from the development to waive financial information, tax returns, et cetera. There's a number of those within the consent agenda, and I was just, I understood that staff was maybe working on a rule change for this. So can you confirm that, Trey?
Yes, and I know, Kevin, I believe that's right. This usually falls under Marissa Button, who fell ill and couldn't make the meeting today, but
Yes, we are aware of the issue here. We are intending to the next rule development to change the rules to allow the board members of a nonprofit to not have to provide their 8821s.
Okay, and what would be the timing of that, you think?
It's usually done beginning in the spring and summertime, and it's adopted usually in the early summer to before the fall happens.
Okay.
Last year, I think, it was approved or adopted effectively in July.
yeah, like July 1st, I think.
Okay. Yeah, I just saw I think there were 5 or 6 of them in here, so.
Yeah.
Okay.
Question on that. So currently they have to provide their income or what is it?
They had to
Financial
provide a
disclosure?
form that allowed us to get their tax returns if we so requested them.
I'm sorry, go ahead.
Allowed us, they are allowing Florida Housing to obtain their tax returns if we so requested them from the IRS.
And you're changing it so they don't have to do that?
No, we don't think they are truly principals in our intent, so that because they're not getting compensation. So we're trying to remove that requirement from that specific definition.
Okay.
But they are signing a certificate attesting to that.
They are signing a certificate
Correct.
saying that they are not getting compensations, which removes their requirement for the 8821.
Okay.
Got it. Thank you.
Thank you. Any other questions about the consent
Yeah,
agenda?
I do have a question, Mr. Chair, concerning the Hardest Hit Fund, foreclosure counseling services. The
this-
funding for that, I believe it's on the consent agenda,
Is it in the consent? Can somebody?
because I didn't see it on the.
It's not on the consent agenda?
That's an
Oh,
information.
okay, so we're going to
Okay.
address that later, or? is
No,
it
you
up?
can address it now.
Okay.
Well, I tell you what, let's move the consent agenda and get that done.
Okay, okay.
All right,
So move.
Second.
Have a motion and a second. All in favor of approving the consent agenda?
Aye.
Any opposed? Okay, now, go ahead, Renee.
Yes, thank you, Mr. Chair. So the funding for the foreclosure counseling comes from does that come from the Hardest Hit Fund? Where
I'm
does that
sorry,
come
could you
from?
repeat that?
The counseling services,
Comes from,
from what fund does it come from?
it comes from a state appropriation from the National Mortgage Settlement Fund
The
back in, I
settlement fund,
believe,
correct.
2013.
Got it, okay. What is the status of the expenditures of that? I know that there was an issue with some senators being concerned about how we're moving those dollars through the system. What's left in the fund? What happened last year, and what's the status of that this year?
Sir, I'm not prepared to give you detail on that, frankly. There is an information item in your
Yeah, in our
package,
packet.
Yeah,
which
kinda-
is called, or at the top, Foreclosure Counseling Program. And the information sheet provides you with information on how many households have been served and outcomes and demographics and all of that. At the bottom of that table, you'll see that about 8.2 million of the 10 million in funding has been reserved. This is over since program inception. At this point, we're reserving those funds at about $975 million, almost $1 million, kind of at a clip at this point. Now the expenditure is much lower. And so what happens when somebody comes into the program, remember the original purpose of this program was truly foreclosure counseling, often with the goal, as often as it could be, to assist this household facing foreclosure to get a mortgage modification. So we reserved a fairly hefty amount of money, up to $900 originally per household, to help or to ensure that we would be available, or these counseling agencies would be available to assist them through that process, potentially over about a 24-month period. Because the foreclosure crisis has abated, although certainly there are still folks facing foreclosure, we now allow, the board allowed this, the legislature allowed this program to also be used to do front-end housing credit counseling for home buyers seeking to buy homes. And we've just recently talked about making sure that counseling agencies are modifying their financial management training and credit counseling to be able to assist folks who want to move into rental housing, because, as you know, our own development community, property owners, property managers, do seek often to require fairly high credit requirements, et cetera, before moving into properties. And that's just the norm in the rental business these days. So the funds are used across the board for foreclosure assistance as well. And so what you'll see here is, and this is not an average, but this last quarter that this was reported on, about $400,000 was actually expended in funds. So the program is sort of at the phase where it's sort of booming. For a while it was kind of moribund because foreclosures were lessening, and so very little money was going out until we talked to the legislature. And we also put out a couple of $1 million, about $2.3 million through the SHIP communities also for homeowner counseling. So that's my summary at this point.
I thought you weren't prepared. You gave me like a 10-minute answer. It sounds to me like you're pretty prepared.
If I said that, I just needed to give myself those few seconds to have all of it sort of flow back in.
Well, just as a follow-up, so it's fee for service? Is that what it is? So
with the counseling agencies,
somebody
yes.
comes in, they need counseling, they get it, and then the agency bills us?
Yes, that's exactly right. So they get paid on the back end for services that they put into the database and invoice us for.
And how do they bill it? Do they bill it on a monthly basis?
They can bill it monthly. We do pay as often as monthly for those who submit invoices.
And how much does it cost per counseling session, I guess?
It ranges depending on the service. So it's typically, this is just a real big ballpark, but it typically will be $50, $75, but it can be a little bit higher. If you close out, once you close out, you get more money, like $500 or whatever. The idea there is to encourage folks, encourage counseling agencies to work all the way through with
So
somebody, like to get a modification.
Right,
but we don't do as many of those anymore, So
what's the purpose now? You're not doing that many modifications. What's
it's
the purpose?
homeownership counseling, it's credit counseling, financial management education. You know, I didn't grow up, I didn't have access to credit cards when I was a teenager and in my early 20s. Now, it's pretty scary out there if you never learned to manage money, right, as growing up. So there's a lot of financial management education that is part of this as well. And as I said before, it's also credit counseling related to getting into good rental housing.
Now, these agencies, do they come in and out of Florida Housing, or is it a contract? How does that work?
We have contracts with them. They were required to come in through a request for, I think, qualifications, RFQ. Initially, we brought those to the board, and so they have contracts with us. And we're pretty stable at, I think, 40-something agencies around the state right now.
They have to be HUD approved?
Yes, nonprofits.
HUD approved nonprofits. So some could exit Florida Housing and others can come in, or is this done on an annual basis?
I believe that
How
the
do we bring them in?
RFQ, it was a rolling RFQ that was
Rolling.
open, but we have not seen anybody come in a very long time. We
Have
could
any
certainly
exited?
see folks exit, but I don't have any stats for you on that.
Okay, that's great. Thank you, Nancy.
You're welcome.
Thank you.
Thank you.
All right, moving on, you might as well sit right there, because you're
I'm
on
gonna
the,
get my water.
you're on the seat on an update to our portfolio. Let me make a comment while she's getting that. And last meeting, I kind of deviated from what I had written down, and it did not turn out so good. So this time, I'm going to try to just read what I wrote down and stick with it. But as I mentioned at the last board meeting, I believe it's the board and the corporation's responsibility to formally address the issue that came to our attention in September of 2016. We're talking 2 years ago. I was on the board then, it came to attention. A lot of you weren't on the board at that time. But anyways, that was that there needs to be some way to help preserve the units we have out there in our portfolio. At the last board meeting, you saw the first iteration of the information that Florida Housing staff assembled and some conceptual strategies that they put together. This information was based on facts and discussions with stakeholders from both sides of the issue. Many of you provided some very good information at the July board meeting, and after that meeting, I sent Trey some additional questions that were generated from those comments, at least in my mind. Florida Housing staff has continued to work on this issue in a professional, non-biased manner, and they have refined some of the conceptual strategies, and that's what Nancy's going to go over some today. The work is not done, but I feel Florida Housing has made a lot of progress and will have several proposals ready for the board action in the very near future. Last time I said September. I will not commit to a month. It's a very near future. Nancy is about to provide us with an update on the preservation issue, and I want to encourage your board to ask questions. This is your format. As you know, because of sunshine laws, we can't get together and just discuss it off to the side. So please bring it up in the board meeting or one-on-one with Nancy. And she, believe me, does not share your comments with me as she shouldn't. So she addresses it fairly. After the board's comments and questions, obviously anyone in the audience that wants to say anything can get up and address that and have an opportunity to make comments. One other thing, Nancy will be reaching out to some of you for some additional information in the coming week, and I would encourage you to please respond to her, preferably in writing, so that it doesn't get all jumbled up and we don't misinterpret anything, as quickly as you can. Because like I said, we hopefully in the very, very near future, in the near future at least, we'll have some items, and maybe not the final of everything, but we'll have some things that we hope will help both sides of the issue as we get into it. Once again, before Nancy starts, I do want to thank the staff. I'm truly amazed with what has been done on this issue. Nancy, Laura, I'm sure there are other staff members. Those are the two I primarily deal with, and Trey. I want to thank you for everything you've done. It's truly outstanding, and I know it was not on your plate at the beginning of the year, but you've done a great job. So thank you, and with that, Nancy, it's all yours.
Thank you, Mr. Chairman. You should have received an information supplement via email, I think maybe on Monday. And then I think at your desk, you also have an additional hard copy, and it's online for those who are interested in reviewing this if you haven't seen it, where our board package is normally found on our website. I want to just briefly go over the data that we provided to you. This was a part of some of the questions that the chairman asked for. We provided you 3 tables with information. They are various summaries of the same information, but it's exhibits A, B, and C in that supplement that's at your desk. So really, this information is provided to answer the question, what do we have coming at us, and how quickly do we have it coming at us? And so what you'll see, and maybe you could look primarily at Exhibit B, the second table, and then we'll talk just briefly about the third table. But Our two oldest properties in our system, one's 32 years old and one is, I think, just 30 years old. One in Broward and one in Orange. These are old bond deals, bond-only deals. The set-asides are pretty high on them compared to the set-asides that we put in place nowadays, but are allowable for bond-only deals. So 20% of the units at 80% of area median income, and the rest at 150%, basically market rate, 150% AMI. Exhibit B shows you by county size that over 47 properties are over 25 years old, and then as you get into the next group, the 21 to 25 years old, you'll see that there are more properties and more units coming. And as each 5-year period passes, even beyond this that we gave you, just looking to kind of properties that are over 20 years old, what you're going to see is that properties are going to get larger and larger overall. We've moved back now in 2018, in the most recent few years, to seeing smaller and smaller properties. But for a while, and certainly when I got to Florida Housing in the early 2000s, we regularly saw property sizes of 200, 250, 300 units. So those are sort of still to come. But 26 to 30-year-old properties, you've got about 3,000 units there, and then in the younger set of properties right below that, you've got about 3 or 4 times the properties coming along, but you've got 7 times the units, which just shows that slowly but surely the number of units in a property will be increasing. We've also provided you with the Exhibit C table, a detailed list of all of the properties that are 25 years and older. We can certainly provide you any other data, well, I shouldn't say any, but much information. We can certainly give you a list of younger properties. If any of you want an Excel spreadsheet that you want to fool around with, we have that for you. But this exhibit gives you a sense of the actual names and locations of properties, what kinds of funding go with those properties, the year of the subsidy expiration, which, remember, is not necessarily the same as the age of the property. And for all of this data, we took out properties that are actually older, but they already came in and got a good amount of preservation funding, and so they're age-wise they're older, but they were recapitalized, and so really they're not part of this discussion at this point, even though they're in the portfolio. So the good news, I think, with the data is that we don't have a huge number of developments staring us in the face that we have to be really worried about. What we're at a great point to be able to begin, as we are doing right now, to put these strategies in place so that we, as the number of properties increases, we are more and more capable, I guess you could say, of addressing how we want to preserve them. I'm going to just move on and give you a couple of brief remarks to summarize where we're at with the preservation plan, and then if you want to ask questions, well, anytime, of course, interrupt. So Exhibit D here behind the tables gives you the current version of the action plan as we're developing it. So as a reminder, we have 6 program strategies, and just as importantly, 6 internal or infrastructure strategies to ensure Florida Housing's capability and how we're going to prioritize properties for resources and at what level, and the work that we'll have to do with owners to implement those strategies. We believe that program strategies 4 through 6 on this list are complete and won't change. That is, unless there is discussion either from the community or from the board. We're not expecting, we believe those strategies are for now as fleshed out as we can make them. They're sort of future strategies, but they're in place so that we can see the panoply of what all we need to do. And those are mainly related to additional allocation of precious resources. And what we've suggested to you as a staff is that we focus first on the strategies that don't require additional precious resources, to save the precious resources both for new construction as well as for perhaps just the highest priority preservation developments that come along, which have not been determined yet. And that's part of our infrastructure sort of strategy, to develop that approach so that over time, as those kinds of properties come in, we'll have a way to prioritize them. Likewise, the infrastructure strategies, which are the last 6 listed in this plan, are pretty much built out for the plan, unless, again, there are comments. We're going to ask for operating budget in 2019 for a couple of these, as we've indicated in here. Those will be part of the operating budget proposal that comes to you at the October board meeting. Others, we're initiating implementation now. None of those strategies are being put off at all. That we need to implement them now in order to be capable of implementing the program strategies. So it's really the first 3 program strategies we're still fleshing out in the action plan. And as the chairman indicated, we are expecting to have basically I guess you could say, our final version of the proposed plan ready for you. We're really hoping at the next meeting so that we can have good board discussion and community discussion. So for the first strategy related to properties that currently have existing sale loans, we've completed a proposed term sheet, which is Exhibit E in your supplement. Laura will summarize this in a minute, but I wanted to go back to something the chair said before I turn it over to Laura. We've got one request, which is for strategy 3 in here, which is on page 2, right? So that's the top of page 2, changes to allow a portion of units at a property to serve higher income residents to provide recapitalization rehab financing. We are requesting owners of properties that originally received 9% housing credits, and just the 9% credits right now, to provide some information to us to help us with this particular strategy. So as these properties reach year 30, there should be a good amount of accumulated equity that can be paired with 4% credits and bond financing to create a good level of rehab and recapitalization to take those properties to year 50, which is the typical affordability period for most of these properties. Before we make preliminary decisions without a property-specific viability analysis, which would come later in the life of that property, closer to year 30, we'd really like to see why this type of transaction wouldn't work as we're sort of thinking here and putting, I guess, final touches on these strategies. So I'm asking interested owners to show us conceptual development and operating pro formas to help us finalize the strategy. We'd like to get those very soon just because it'll take us a lot of time to ask questions. We'll probably talk to our servicers. They'll help us a little bit with this. And it'll just take us time to talk it through internally. And I commit to sending out, one of us will send out a request for this information. Maybe we'll give you some term assumptions to use. You may want to come back and tell us that's an inappropriate assumption. Here's the assumption I want to use and why. But it will just really help us further kind of educate ourselves and think through to prepare for a final, to bring you a final strategy. So with that, unless there are any questions, Laura could go over her summary. And
all right. Good morning, Mr. Chair and Board. For the record, I'm Laura Cox with Florida Housing. So I'm going to talk to you about the first strategy on page 9 of the action plan. And this is the one targeted to older sale properties, which will require some capital investment, but don't require significant rehab funding to remain viable. This strategy would permit first mortgage refinancing that would include new funds to be used solely for capital improvements. Currently, for any increase in the balance of a first mortgage, the rule requires a proportionate amount to be paid first to accrued sale loan interest and then to sale loan principal. We anticipate this pilot would provide approximately $5,000 to $10,000 per unit of rehab for sale properties. And the term sheet in your package as Exhibit E that Nancy pointed to lists the information we expect the development community to have to provide to the underwriters to perform their reviews. I'm going to focus mainly on the terms that we are crafting for the pilot. So eligible, and that's also on the Exhibit E, eligible properties will be at least 20 years old. They will waive or have waived their qualified contract rights if they have tax credits associated. They'll be affordable for at least another 10 years after the rehab. They will not include developer fee or any cash out to the owner. They will have replacement reserves of $300 per unit per year, or as set by the capital needs assessment that is required for this refinancing. They'll have limits on third-party financing costs, closing costs, and prepaid, so they won't be prepaying replacement reserves with the new funding for the first 5 years or something like that we've seen in some of our transactions. They will require the renegotiation fee that's part of our rule, as well as fees to Florida Housing's legal counsel for closing the loan, the servicers for their underwriting, and their agents for like the construction inspection that they perform, or the plans and cost analysis review, the typical items. And we will be announcing a workshop later this month or sometime this month, the announcement, to seek more feedback from stakeholders so we can get their input and work through this strategy some more. And if you have any questions, I'm happy to answer them.
Okay, thank you. Any comments from staff? No. Once again, I encourage the board to ask questions. I've certainly inundated them with questions over the last 9 months, I guess, or 6 months we've been working on this. Mario?
Yeah, I have a number of things. So I'll just state so the board knows that on September 4th, I did send an email to staff with a number of thoughts and suggestions around, the preservation issue. I guess first and foremost, I'll state that because I believe, and I wasn't here for the July meeting, but did watch the video. I know that there is some urgency around this whole topic. But, with regard to, I think it was brought up that there may be a suggestion for a change from the 50-year affordability term to 30. I think that, to maintain the existing housing stock and grow it as we do with the new deals, that, we shouldn't, be touching the 50-year affordability term. So I'm just stating that, for my opinion on this. So obviously it leaves us with, preserving the older stock. So a lot of this deals with, it looks like more minor rehab, these strategies. And so can you tell me again how we're going to deal with, larger rehab requirements, say in the $20,000 and $25,000 per unit range?
So we believe that if you look at your strategies, we believe that strategy 2 and strategy 3 are both larger recapitalization strategies. It might be fair to say that strategy 2, which is the use of 4% bonds to recapitalize properties at or after 15 years, is kind of the medium strategy, maybe for moderate rehab purposes, and is actually being used now that way. But we've talked about some barriers that we're working on right now with talking with the development community and investors and lenders. And then I think strategy 3 in here is, I think the intention is without putting precious resources in, right? Because that's what we're talking about, those other strategies. I think strategy 3 is the one where there's some more intensive focus from some in the development community to sort of see that strategy and craft a strategy that would provide more rehab. And, for a property reaching 30 years, that's a 9% property. you know, we shouldn't be seeing rehab amounts like we see with our classic preservation deals right now, which are anywhere from $35 to $45, typically $1,000 per unit. Those deals are typically 40 years and older, the ones that are coming into us. So we are looking, but I think with this, it's probably in the direction of what you're talking about.
Right. Yeah, because I think one of my suggestions in my email was, you know, considering, a property conditions report that, you know, shows useful life. And my suggestion was like 15 years, you know, to go beyond 15 years in terms of useful life of major systems, roofs, HVAC, et cetera. Is that being contemplated in the term sheet in terms of, you know, determining useful life?
So if you're talking about the strategy that I was talking about, there will be a capital needs assessment.
Mm-hmm.
Typically, the first mortgage lender will require that. If they don't require it, we'll require one, but I'm sure they'll require one. And they do look at the remaining useful life. They look at the reserves. They do, and I'm sure you're familiar with them. So yes, that will be looked at in what we were talking about, and I'm sure we'll discuss this more with the stakeholder community. If there are 5 years left on the roof, we're not going to replace that roof, but we will adequately reserve for it when it's the appropriate time. So does that answer the question?
Yeah, that answers my question.
Right, and I think for all three of these first, well, really for any of this, the capital needs assessment or some sort of tool like that is really critical. And we have incorporated into, and I think it's either most new developments that we're financing now, we require a somewhat regular capital needs assessment so that we're looking at our replacement reserves vis-a-vis what the CNA says is needed, so that we're trying to think less like a new construction shop and more like a, you know, portfolio asset management shop now, I guess it's fair to say.
And the rule requires it by the 10th year if there's not one already provided by another party, like the first mortgage lender or the investor or something like that.
Okay. So I guess with regard to the strategy number 3, I just wanted to hear a little bit more about, and I know your analysis is kind of ongoing with this right now, but I wanted to hear more about the income averaging, because I believe that, you know, with regard to these projects, you know, the ones that are older and needing more substantial rehab, is that, you know, there really needs to be some sort of, you know, incentive for the owners to actually put the money in the project, right? So I believe that, you know, this 80% AMI is an interesting option, but I'm not sure how the income averaging comes into play. It seems like it may limit it a little bit, so I just wanted to hear you a little bit more on that.
So income averaging, the great thing about income averaging is it can provide a little bit more cash flow at a property. The downside of income averaging for recapitalization purposes is that it probably doesn't provide enough income for like a 30-year recapitalization strategy. So I don't think that this strategy at this point was intended to be an averaging of income. So income averaging that Hugh talked about earlier in the meeting is really where in all across the development, the rents cannot be any more, the average rents, and I know I'm saying this a little wrong, cannot be more than 60% AMI. This strategy is not making an assumption that that average will have to be maintained. So we're not saying, and to be clear, there is an option 1 here that if a development wants to go in that direction. Remember, every unit you say, I don't want it to be under tax credit requirements anymore, you can't get financing for that through, say, 4% housing credits.
Right.
Some developers may want to come in and say, I still want to use the tax credit program in all of my units through the 4% process. So income averaging would allow them to do that.
Mm-hmm.
And there's one caveat. So if you had tax credits before that change to the code, you cannot income average until your 30-year period has expired. So those folks don't have the availability to do that.
But there's going to be other folks, we understand from conversations that we've had, who think the idea of being able to step for some of their units, for a portion of their units, to step outside of the housing credit regulations and move those units up to 80% of area median income, that they would be able to then access additional private financing that would perhaps more than make up for, that's certainly the way I think they're thinking about it, more than make up for because of the income that would be coming in. Now, of course, the problem with this approach is it's great for areas of the state where you can get those higher rents. This is not going to be a panacea, this strategy. In many areas, many markets where our properties are located, where the community's poor, right? So we're definitely not solving all the problems with this, but.
Yeah, sure. I realize that. But like, you and I sat down at the Affordable Housing Conference, and, we understand that every deal's different. And just like you do with new deals, you're trying to solve for the cost, right? And, figure out the capital stack. I mean, I don't see it as any really difference here. There's going to be different, and I like the fact that we have a number of strategies here, but, you are going to apply different things, to different projects. But I want to thank you for all your hard work on this, and, being open to meet with me and, allow me to understand, the process that you're going through. Thank you.
Thank you.
Thank you, Mario. Yeah, Ron?
Sorry. So the 4% tax credits, that's going to add additional funds for renovation after 30 years? Is that basically?
It can. If the right. I mean, in some cases, based on the financials of the development, what we've heard from some property owners is that a 4% bond transaction, so just 4% in bonds with no sale or anything, will not by itself provide them the level of recapitalization that they need to rehab their properties, which is why I asked for information so that it will help us. Yeah. So for some, some are already, some in our portfolio, folks aren't really doing much of this at 30 years because we just don't have that old a portfolio yet.
Okay, so are we going to look for additional sources of funding to help in some way?
So the Strategy 3 concept, option 2 and option 3, propose that developers, and it's vague right now, admittedly, propose that an owner could, either coming in and getting a viability analysis from Florida Housing, working with Florida Housing, would be able to either have a guarantee of or be allowed to take a certain percentage of their units up to 80% of area median income. Thus, I suppose, if they don't choose income averaging, taking those off the tax credit roll, allowing them then to go to the private sector to get the additional financing that would match up with that 4% bond, or not do 4% bonds at all, actually go outside. Some folks have said, taxable financing is cheaper right now. And I think it's really going to depend on the real estate market, the financial market at the time. I mean, this is all such a beginning. We're going to have to move this around as we grow into it.
It's going to be difficult.
Yes. My understanding, when I first started to do some work around preservation years ago, for the initial preservation strategy, which we have in place, where we put 9% credits into those project-based rental assistance deals, the really old ones, everybody said, at other HFAs, state HFAs that were doing this already, said preservation transactions take more people, more time to do. They are the most complicated to do compared to new construction. Just absolutely no question. So yes.
And will we need any legislative changes in what we do?
I think it's too early to tell. We're we're looking at the sales statute. I think we're, right now we believe we need a rule change. I think it's too early to tell, wouldn't you say? Yeah.
And as we flesh these out more, we'll be able to. For some of them, we don't. We clearly have authority. So.
I had another follow-up question on the option 6, which I know is not our focus, but I wanted to understand allowing certain properties to exit the affordability period. In terms of, I understand that this is going to be in areas of much lower income areas of the state. But what's the advantage of allowing them to exit and, go to market rate, which is probably very similar to the rents that, are being obtained, at the project, now?
Speaking frankly, there's probably less advantage to the community where that property is located. One of the concerns brought up by a board member many years ago, when I first got to Florida Housing, was related to her concern that in the future that our portfolio, as it got older, she didn't want slum properties in the portfolio, is what she said, and I remember thinking at the time, how will we ever have enough money to help preserve all of these properties? And a property in an extremely low-income area, which may be an important property to preserve, and we may decide to prioritize it, but from a viability point of view, needs our funds more than probably a property in a higher-end area, and yet, just looking at it purely monetarily, those rents aren't going to change if we lose that property. So what is the balance? What do? We don't have enough financing to preserve every property and continue to build new. That is it's a problem to think about. It's not our problem today, but it is going to be somebody's problem going forward.
But I would add that it will achieve some cost savings for them. So they won't be paying for the compliance monitoring fee or any other fees that we have. They won't be preparing reports to submit to us. Their staff spending the time to answer, going through the reviews that they do.
The income qualifying that they do for folks
so
coming in.
It'll save them some operational cost.
Right.
Which then they would possibly consider putting back in the project. That's the theory?
It's the theory. Right. That is the most gnarly thing about all of this. And I know that when Trey and I spoke about all of this, we agreed that putting this number 6 in here was scary in a way. But I suggested it was important to put this in because we may never do this, but that it forces us to look realistically, at least to begin to think, we're going to have to look realistically. So maybe another board will have to look than you all at this on down the line.
And then one last question with regard to the priority. So you're going to develop a priority matrix of properties. Is that the
not
the
of specific
concept?
properties, but of characterizations
Yeah.
or characters of properties or where properties are located, who they serve, that kind of thing that would serve as a beginning point for a discussion, I think.
So what occurs when, let's just say, a developer approaches Florida Housing about a project, and let's just say it could be 20 years old or 25 years old, but they're approaching you and say, hey, this project, needs some rehab. I'd like to try to, put it into one of these strategies. Is that open to developers and owners to do, or how does that correlate with the priority matrix?
I think the priority matrix will be for an RFA purpose.
Yeah, I think the notion with that matrix, I think, was more to assist a future board to think about where you would put your precious, your sale, your 9% credits, and whatever other precious financing we may have, get our hands on in the future, rather than these strategies which are, don't require additional precious resources.
Okay, I understand. So they can just go under option number 3, let's say, and come up and say, hey, look, I need to rehab, my project now. I got a roof that's going bad, and et cetera. And can we, look at option 3, for instance, to try to do that?
Right, and I think that's just like, we get a lot of questions from new developers coming in who want to do new construction, or they want to do an acquisition rehab, and they say, I'm trying to figure out which of the programs you have will work for me. And depending on who answers that call and all, we will sort of push them in a direction. We'll ask them a bunch of questions and then make some suggestions to them about sort of how they can do some research to figure out which RFAs might work for them. So I think this would be the same.
Okay.
And I think it's fair to say that our Special Assets Department already does that when we're looking at refinancing sale right now, that we talk to them about what their options are.
And with external providers of new funds, then that all goes through the Special Assets Department.
Right.
Thank you.
Okay, thank you. Let's get some audience comments now, if anyone would like to address any of the issues on this that we have. Please state your name and organization. The mic's right here in the front.
Good morning, Chairman, board members, and staff. My name is George Lopez, and I'm with the Cornerstone Group. I'm really glad that this issue is coming to light and being addressed, and I want to thank staff for their work. I haven't seen the strategies that they've proposed, so it's a little bit difficult for me to comment on the detail on everything that they have done. But I do want to point out a couple of things. We have a portfolio that has about 60 properties. We have a number of them, probably 3,000, 4,000, maybe a few more units that are within the 15 to 20 year period. And I will tell you that those properties, at the end of 20 years need a substantial rehab. And they vary by property, but overall, they all need a substantial rehab. You can see it in the quality of the units when you walk, when we're turning the units after a move out, et cetera. I want to point out a couple of things that, in my opinion, are important. One is when you allocate resources, if you're going to allocate resources to these rehabs, they're going to need a substantial amount, because it doesn't really solve the portfolio property to go in and have me compete against Louis Sweezy, which I know owns several properties that are also in the 20-year range, and get into a competition. That solves the problem for a few properties, but it doesn't solve the portfolio problem. That's one. Secondly, I think new resources should go into increasing the housing stock. It's very important to continue. The more housing that there are at whatever level, whether it's 80%, targeted at 120%, or market rate, that brings the overall rents in the market down. So I would just be cautious as to how much of the new resources should go into the existing portfolio versus producing new housing. Another comment that I want to make with regards to the 4% tax credit. It may work on some transactions, and we've done one. We're looking at doing a second one with the 4%, but it's in limited cases that can work, because the nature of getting 4% credits means that you have to sell your property. And so you have to sell it into a new entity in order to qualify for the majority of that tax credit, which is the acquisition credit, which is recapturing the equity that staff talked about. When you do that from an owner-operator point of view, it causes a couple of problems. One is you can't, as the owner, sell that property and qualify for tax credits if you own more than 50% of the entity. So by nature of getting a 4% credit, you have to divest of the property. It has for the operator, it has a big recapture event. So, those two things combined alone, is going to require bringing in more resources to do that renovation. So, there's a number of issues with that. Back in September 2016, we, and with staff's recommendation, brought a proposal to the board for 7 or 8 of our developments that had been financed originally with tax-exempt bonds. They all had a extended use agreement into perpetuity. And so what we were able to work out with staff was a compromise. We said, look, many of these properties, and particularly over the last 10 years, many of these properties haven't had rent increases in 8 or 9 years. So what we worked out with staff was a compromise. Instead of being in perpetuity, they allowed us to go through the qualified contract process. In exchange, we committed that if nobody made an offer to the properties, we would commit to do 85% of the units at 80% of median income, so that would give the property more income. That would give us the ability to renovate the properties. And in exchange, we committed in those developments to doing 15% to ELI. And that was really a huge benefit to the community, a huge benefit to the agency, because if you look at the cost of providing a new ELI unit, it's well over $100,000 between when you look at the tax credits and 9% credits, the sale loan that goes into it, the ELI funding that goes to it. It's a huge amount. So, we thought that was a real win-win, and it could be applied globally to solve a lot of issues, still providing workforce housing. If you look at the Schimberg study that was done a few years ago, the biggest housing need was in 2 categories. It wasn't serving people that are at 60% of median income, because that's where all the funding has been targeted to for 20 years. But there's a big need here for workforce units. People that are making above 60% of median income. We have a number of those people in our properties, and they're locked into our properties. They can't move, because in Miami or Broward, if you move from an affordable housing property that you qualified when you moved in, your income went up. Now you have to go get another unit. You're going to pay twice the rent. So you're stuck. It doesn't provide mobility. It doesn't provide. So creating that 80% of household is very important. And we don't have to talk about the need for ELI. Everybody knows the need for ELI, special households, elderly people. They can't afford 60% of median income. They need a lower rent level. So it really addressed 2 issues. It's something that could be addressed, globally. I don't know if that's in the staff's recommendation, but, certainly, look at that. And I think the key is to act, because they're 15 to 20 years old now, and to do something that solves the problem on a global basis. Thank you.
Thank you. Yes, sir.
Since George mentioned my name, I figured I'd get up and say something. Okay, I'm Louis Sweezy with Centennial Management. Another issue too, particularly in the large counties like Dade and Broward and Palm Beach County, where there's such a concentration of need for affordable housing, they've been saturated and hit very hard between the 60% of medium category. And what we notice is when we get applicants that come into our properties, we get a lot of them who come in and they're still in need, but they might make 65, 70% of medium income, so they don't qualify. And, what you're doing is you're serving 2 goals. You're upgrading the preservation stock of the state of the affordable housing. You're meeting a different target that hasn't been met. When you meet every county commissioner in Dade County and in Broward, they seem to want, particularly in the hardest hit areas, they seem to want more workforce housing, more than affordable housing. And that seems to be the goal of the local community leaders, but yet it's not being addressed in an adequate manner. And this is one way you could do it without taking any other subsidies from the 60% and bring up the goals of providing a market niche that's been kind of neglected so far. Thank you.
Thank you, sir.
Thank you.
I will ask if you're going to make some comments, if you kind of just line up maybe behind the mic and we speed this up a little bit.
Hi, Suzanne Cabrera. I'm President and CEO of the Housing Leadership Council in Palm Beach County. I'm also on the Florida Housing Coalition Board of Directors, but I'm here today speaking with the Housing Leadership Council. And I have heard the rumors about reducing the affordability term below 50 years. And I was around when this first came in, and actually 50 years was a compromise. We always wanted perpetuity. And I'm just really concerned about that these are precious resources, and I think that it's really important. It's not like this program does not have people applying to it. It's oversubscribed. They're lining up in the door to get into this, but I have heard some developers make the argument that they just can't make it work financially if it's not reduced, unless it's reduced to 30 years. Well, there's plenty of people that want it, so if they can't make it work, don't apply. Well, you'll still have plenty of applicants for these funds. So I think that's really important, and I'm glad to hear that there's at least one board member concerned about that as well, because it's something that is so important. Palm Beach County, our area median income is over $74,000. It's artificial. Median goes right to the middle. Our average wage is so much below that. So I also have concerns about reducing or going up to 80% of AMI, because in a lot of cases we have trouble people meeting that 60%. Our teachers make less than 60% of AMI. So I can't tell you how much I appreciate all the work in this, and I will have more input on this because preserving these properties is important, but I just have to speak up about any reduction of the affordability term. I think that's so important, and we really need to keep that housing stock affordable and preserved, and really take care of those precious resources. So my thanks to the staff and the board for addressing this issue. It's really important.
Thank you, ma'am. Thank you. Again, if you're going to speak, please go ahead and come up and stand behind this lady so we can move this along. Go ahead.
Hi, good morning. My comments are not specific to preservation, but in general.
State your name.
I'm going. Okay, sorry. Hello, Olga Golik. I am the incoming president of the Florida Supportive Housing Coalition. You may have met before Shannon Nasworth, our former chair, who has passed the baton to me. She will continue in her role, though, as a policy advocate, so you'll continue to see her, but I wanted to introduce myself and also to welcome you to South Florida. I do work for Citrus Health Network, a South Florida provider, and we're glad to see a board meeting here and glad to see some members from South Florida. Citrus Health Network is a service provider. We don't get housing money from Florida Housing. However, we provide healthcare services, behavioral health, and primary care. And we recognized years ago that housing was a health determinant, and we have been providing housing assistance to our patients for many years. We serve probably over 1,000 people with some type of housing assistance every year. So we recognize what the needs are. So as the coalition, and from Citrus, we thank you for your support for housing for the most vulnerable populations, people with special needs like ELI groups, homeless people, and persons who are disabled or aging out of foster care or victims of domestic violence. All of these groups still continue to have a housing need. There is not a saturation of affordable housing in South Florida. We continue to see people returning to homelessness on a regular basis. We encourage you to continue your efforts that you've been doing in support of housing and homelessness. We encourage you to dig deeper, like the pilot program that focuses on the very high utilizers. And we thank you for the support that you've had and look forward to continue to working with you. Thank you.
Thank you, ma'am. Any other comments on, I guess we'll open it up, either the preservation plan or any other public comments? Seeing no one standing up. Once again, I'm going to say it one more time. If you got something to say, please get in line, or this
Okay,
is the last lady. Go ahead.
Thank you. My name is Maura Merkel, and I am a private citizen. I am a member of the National Alliance on Mental Illness and a volunteer. So this is not my job. This is my heart and my passion. And I just want to speak for the special needs, the mentally ill, those who are on the extremely low income. We're talking $750 a month in Palm Beach County. And it's very, very challenging. I think we need housing at all levels, but don't forget about the needs, whether it's smaller units or more units, together, however the financing can be done. There's an invisible need, and I just want to say they're there, and the need is great. Thank you.
Thank you, ma'am. Thank you, ma'am. Okay, any other board comments? And seeing no one got in line, the meeting is adjourned.
We didn't break any records today.
No. I might break the record trying to get to the airport and trying to catch a plane. Anybody going to the airport? All right, see ya. Hey. Oh,
They're
no.
good, thank you.
Now I got to sign that crap.
Yeah, that was